Weekly list item number 3.
Last occasion, Lordship is pleased to direct the Lawrence State Council to obtain the instruction from.
There is no order passed in this.
Yes, Lordship. That day, your Lordship directed me to call a report from the Child Welfare Committee because the girl is.
Oh, without any.
Acha, without
Yes, yes.
opposite party number 3 to cause production of the minor daughter.
Yes, yes,
Opposite party number 3 key.
And
Two,
Female DC.
Or 2.
2 years.
What is your prayer in this writ petition? Acha, from the custody of opposite party number 2. Acha, opposite party number 2 is the
Child Welfare Commission.
So what report has come, Mr.
Lordship, kindly have a glance to the last page of that report, my lord. We have made a date chart also.
Date chart kon aage koi jaan.
Again, Shachare, we have rescued that girl. Thereafter, we placed it for the welfare committee as per the section 31 of Juvenile Justice Act. And thereafter, we counseled that girl, and girl did not want to go with her parents. And thereafter, now she is reading in class 8 in a school. We have took her admission in a school, my lord. What has happened? The background of the case is like that, your lordship. The girl was 13, 14 years old girl. He was sent with that boy, one boy. Thereafter, that boy forcibly married that girl. And it enjoyed with that girl, sexual intercourse did. Thereafter, that girl rescued from that boy. And we came back to his village. And when the boy came to take that girl, the parents insisted to go with that boy. At that time, some village quarrel, that time somebody had made complaint, and thereafter this child welfare committee has rescued that.
have intervened.
This is the
As I was submitting last time, my the conviction is totally based on the
Lady judicial officer could have put for your lecture. So this matter has earlier been heard for some
Yes,
time, I
yes,
think.
yes.
Yes. So what is this case? Just to recapitulate.
When Panna and Sajna, two sisters were quarreling, my lord.
Konada?
Two sisters were quarreling, Sajna and Panna. Thereafter, Sajna went to call the deceased. Deceased came to the spot and asked two sisters why they are quarreling at the instance of others. That other is the accused. She thought he is telling to me. Therefore, she went to her house, brought a knife and stabbed the deceased man.
Okay.
And the PW8 is saying ki I was all through the incidents, I was seeing the matter.
So there is an eyewitness to the occurrence.
PW8 man.
Okay. So please place it, just recapitulate.
PW8 my lord, page 66.
Then why it was adjourned to today? Or
Because it is spot map is very important in this case, my lord.
no,
Because he is saying I have seen all this matter, and my submission that it was a dark night.
See that order sheet. Oh, it is not mentioned why it was adjourned.
Because it could not be
Your lordship
finished.
wanted to know about the distance from which he has witnessed it, because that is not available from record. I also verified.
Just place it so that let us place that eyewitness statement. That is PW8. He is the sole eyewitness.
Yes, on the basis of which conviction.
Okay, all right. Just place it.
Page 66.
Yes, please.
I know the accused who is standing in the dock, and also the deceased Banwadi. The occurrence took place about 1.5 years back. On the date of and time of occurrence, I, along with Arakita Bhoi, was sitting on the veranda of Bhajasau in the evening at about 8
Arakita Bhoi has not been
examined, my lord. At that time, Panna Varia and Sajna Varia, both two sisters, were quarreling with each other. At that time, the accused Rukmini was also present. Sajna Varia, PW3, called to the deceased Bonnamali. Bonnamali, the deceased, came there and told to Panna and Sajna as to why they were quarreling at the instance of others. Rukun Meher, the accused, thought that the deceased Bonnamali was saying her. Thereafter, she went to her house and brought a knife and stabbed to the deceased at his 2 to 3 places. Police came to the village for investigation.
So, as it appears, the deceased was a peaceful intervener, right?
Yes.
But this appellant is under misconception.
Yes.
As it appears, perhaps the deceased was hinting at him. That was the problem. That is why he took it as an exception and brought that knife and stabbed. That is how it develops. Okay, continue.
Police came to the village for investigation at about 9 to 10 p.m. The police asked to the accused by which you stabbed the deceased. Thereafter, the accused produced the knife, the weapon of offense, to the police. The accused brought the knife from the ura of her house. I had seen when accused brought the knife from the ura of her house, and police seized the knife in my presence and prepared the seizure list. Exhibit 4 is the seizure list and of knife, and Exhibit 4/1 is my signature there. Police also seized the blood-stained earth and sample earth from the spot and prepared the seizure list in my presence. Exhibit 5 is a seizure list, 5/1 is my signature there. I can identify the knife if shown to me. The witness identified the knife which was seized by the police marked as MO1. That's the cross-examination matter by the state defense. Two persons, namely myself and Arakita, were sitting on the veranda of Bhajasau and talking to each other. We sat there for about 2 to 3 hours. We saw the occurrence from the place where we are sitting on the veranda of Bhajasau. My house situates at a distance of 100 feet from the veranda of Bhajasau. My lord, may mandal and this line, my lord.
This the distance from Bhajya's house
And his
to that place of occurrence is relevant, not the.
This
I'm
house.
saying my baby, kaha.
Yes.
In between my house and veranda of Bhajya Sahu, there are houses of accused Rukmini Meher and Arakita Meher. There are 3 houses in between the houses of Panna and the houses of the house of the deceased Bannamani. The house of Suru Bharia, Chandra Bhoi and Kesav Bhoi are adjacent to the house of Panna Bharia. My house situates at the right side of the village road and the house of Panna and Sajana situates at the left side of the village road. Our village land is running south.
South.
No, it should be road, my lord.
But what is the where you have brought out the distance from the place where they were sitting? This
Bhajya Sahu.
That is Bhajya's house. Bhajya's house to that
Place of
spot.
occurrence.
It has not been brought out, but
So if it is not brought out,
yes.
you cannot we cannot overlook that they were co-villagers. Okay, and they are quite accustomed to each other. It was at 8 p.m. Okay, and so how do you say that about if you are all advancing your argument regarding that it would not be possible from a distance to mark who has assaulted whom because it was a night, but for that you are to bring such a situation from the through the cross examination. If first of all you have not brought
Yes.
that what is the distance from the house, is it there in the spot map that what is the distance from that Bhajya
spot map not here.
Bhajya Sahur ଘର ବାରଣ୍ଡାରେ 2 ଜଣ ବସିଥିଲେ,
ଆଜ୍ଞା।
ଗୋଟେ ହଉଛି PW8 ଆଉ ଗୋଟେ ସେ ଅରକ୍ଷିତ ସାହୁ ଏକ୍ସାମିନ ହେଲାନି, ତ ସେ ଭଜ୍ୟ ସାହୁର ଘର ପାଖରୁ ସେଇ ଯୋଉ ସ୍ପଟ ଟା କେତେ ଦୂର ସ୍ପଟ ମ୍ୟାପ ରୁ କିଛି ଜଣା ପଡୁନି,
ଏଠି ନାହିଁ ଆଜ୍ଞା।
ଭଜ୍ୟ ସାହୁର ଘର ଦେଖେଇନି
It's a
ସ୍ପଟ
spot
ମ୍ୟାପ
map is not here.
ସ୍ପଟ ମ୍ୟାପ ବି ପ୍ରିପେୟାର ହେଇନି।
नहीं ये नहीं क्राइम डिटेल्स नहीं।
ଆଚ୍ଛା ୟାଠୁ ସିନା ଆଣିନାହାନ୍ତି ଅନ୍ୟ କୌଣସି ସାକ୍ଷୀଠୁ ଆଣିନାହାନ୍ତି,
Distance
ସ୍ପଟ ମ୍ୟାପ ରେ ଅଛି exhibit 9 ବୋଲି କଣ କହୁଛନ୍ତି?
But I have not received that.
No,
Not in the
that
paper.
is all right, but you said that exhibit 9 ବାହାର କର। Next page, House of deceased. ଏଟା କଣ ଦେଖେଇଛି, ଏଟା ହଉଛି ସ୍ପଟ ଦେଖେଇଛି। House of the accused ଦେଖେଇଲା, House of the deceased ଦେଖେଇଲା, ତାପରେ କଣ ଗୋଟେ ଲେଖିଛି colony। ଆଚ୍ଛା
ABCDE
E 5ଟା ଦେଖେଇଛି। ଏଟା ନାଇଁ ଏଇ ଯୋଉ ଲାଷ୍ଟ ଟା କଣ ଲେଖିଛି E ସେ ଇଏଟା ଟିକେ ଅରିଜିନାଲ ଟା ଟିକେ ଦେଲା ସ୍ପଟ ମ୍ୟାପ ଟା ଟିକେ that is marked as exhibit 9। ହଁ ଲେଖା ହେଲା the spot in this case is village so and so located okay on so and so situated on the western side of the Gala. The house of Rukmini Meher. Rukmini Meher kiye?
Appellant.
Appellant is situated at a distance of 12 meter towards south from the house of the deceased on Karnataka and is located on the west front side at a distance of 5 meters. The deceased Bonamari was found lying on the village lane in front of the house of Pano and Sajana Behera. the house of Sajana Behera and house of Swan So were situated on the western side of the road. On the east house of Swan So ରୁଜ ସେ ଲୋକଟା ନାଁ କଣ ଯାହା ପିଣ୍ଡାରେ ବସିଥିଲେ?
କେଶବ ଭାଇ
ନା ନା
ଭଜ ସାହୁ।
ଭଜ ସାହୁ
Bhajya Sahu.
ଭଜ ସାହୁ।
Sahu and Hatta Bhoi are situated on the Islam direction. Systems of this the it located on the house of Orachita Savashan. And that the I situated is the spot ଟା ଏଠି ଜଣା ପଡୁଛି but ଏ ଜାଗାରେ dead body ପଡିଥିଲା ସେଟା ଦେଖଉଛି ସେଟା କାହା ଘର ସାମ୍ନାରେ ଅଛି? No, have you suggested to this witness that the place where you are sitting, that spot would not be visible?
ଆସିଛି ଆଉ ନାହିଁ ହେଲା।
ନାଇଁ କିଛି ତ ନାହିଁ ଆଉ ଆଉ କଣ ବାହାର କରିଛନ୍ତି cross examination ରେ? Sajana was on the road, on the door. The accused Rukmini was sitting at the door. The house of Pano. I cannot say which place Sajana called on. Came to know Banawari disease are at the spot hearing this.
ସେଇଟା ଗୋଟେ କଥା କହିଛି କି when they are talking I can say what they were thinking। ଏଇଟା ହବା କଥା କି what they are talking ଭୁଲ thinking ହେଇଯାଇଛି। ସେଟା ଶୁଣି ପାରିବନି କହୁଛି କିନ୍ତୁ
Rukmini told the deceased that he was saying, pointing to me. I saw the
accused went to her
sitting
house।
there. That accused went to her house, brought the knife from her Uda, and then when I was sitting, the knife was glittering, and the accused rolled right hand, and the accused was standing. The deceased was quarreling with the. There was tussle between the accused and the deceased. As the deceased protested to the accused, had not seen the assault made by the deceased to the accused. The accused caught hold of the hair of the deceased Panmari and stabbed him from the front, and also the accused pulled him down, holding her hair and stabbed him. The accused stabbed 3 blows. The accused dealt fast blow to the right side belly. The third and fourth on the neck. Stabbing the deceased fell down on the ground.
here he is saying after stabbing the deceased fall down on the ground in front of the house of Keshav bhai।
Cross examination ने सबू आपण डिटेल काढी चंती।
हां ସେଇଟା लास्ट टाइम माय लॉर्ड से कि
की खाली कहला 2-3टा
2 to
ब्लो
3
देला
times
बोली 2-3टा जगह मारला ताकू था छुट्टी धरला ताकू तळे पकेला तार ए जगह मारला सेठी मारला vividly he has described because the cross examination to her and after stabbing so and so there was burst and
he is saying कि the dead body found in the Keshav bhai house in front of Keshav bhai।
ସେ ଗାଁର what is the
ଗାଁରେ ଏପଟ ଘର
ଗୋଟେ
ସେପଟ ଘର
ଗୋଟେ ଘର ଥାଏ।
ଲାଗି ଲାଗିକି ଘର ଗୁଡାକ ଅଛି ତ ଗୋଟେ ଜାଗାରେ ଯଦି ସିଏ କହୁଛି ଏଇଠି ପଡିଛି ବୋଲି ଆଉ ଗୋଟେ ସାକ୍ଷୀ କହୁଛି ନାଇଁ ସେଟା ଏଠି
କେଶବର ବି
ପଡିଛି
ଘର
ତା
ହେଇପାରେ
ମାନେ ନୁହେଁ ଯେ ଏଇଟା ଅଲଗା ଅଲଗା ମେ ବି ଦ୍ୟାଟ ପ୍ଲେସ୍ ଇଜ ଅଲସୋ ଇନ ଫ୍ରଣ୍ଟ ଅଫ ବୋଥ ଦି ହାଉସ କାରଣ ଗାଁରେ ଯେତେବେଳେ 2 ଜଣଙ୍କ ଘର ରହିଛି ଗୋଟେ ସାହି କହୁଛି ଆ ଘର ସାମ୍ନାରେ ପଡିଥିଲା ଆଉ ଗୋଟେ କହୁଛି ନାଇଁ ତା ଘର ସାମ୍ନାରେ ମେ ବି ଦ୍ୟାଟ ଏ 2 ଜଣଙ୍କ ଘର ସାମ୍ନାରେ ହିଁ ପଡିଥିଲା ରାସ୍ତାର
ଅପୋଜିଟ ସାଇଡ ହେଲେ ଇଏ ତ ଦେଖି ପାରିବନି because ଇଏ 100 feet ଦୂରରେ ଥିଲା ଭଜ ସାହେବ।
we cannot anticipate that
you
you
have
are
not
to
brought in
bring
evidence
that ଯୋଉଠି ତମେ ବସିଥିଲ ତା ଆଗକୁ ଯାଇ ରାସ୍ତାଟା ବୁଲି ଯାଇଛି स्पॉट मैप रे अछि गोटे बुली जाइछि
ରାସ୍ତାରେ
आउ से
ଏପଟ ସେପଟ।
तेणु तमे जोटी बसतल से रास्ता बुलिवा परे जो घर गुड़ाक अछि से घर
ଦେଖାଯିବନି।
फ्रंट पोर्शन देखा जीवनी क्रॉस एग्जामिनेशन गोटे टैक्टिस
ନା,
अछि ना
it could have been.
आउ तापरे से जो बुलिवा जगह ठू से जो जगह रे से अमको लोकर घर होची एते बाट सेही सामना रे डिसीज पड़थला सेथुरु गोटे माने हेई थांदा प्रथमे आनी थांदे जोटी बसी थला सेठू से जो रास्ताटा
Spot
एमती जाइकिनी एमती बुलीची बुझिले ना
Yes.
तो ये मनकर एइटी बसथिले आगे आनिथांदे जे एठू से ता दूरताटा केते तापर आनिथांदे से जो बुलीकिन जो घर गुडा के तार फ्रंट रोटा एठू तमे जोटी बसचो देखा जीवनी तापर से जो लोकटा से जोटी से जो लोक घर सामने पड़थला सेठी होची से टर्निंग रु एतेटा घर छाड़ीकिनी एमती एमती आनिकिन तापर आर्गुमेंट रे हेडा जोड़ा जाए हला
So from the evidence of PW11, it seems that the present person has seen nothing, my lord, because the confession was recorded in front of this.
कोन कार
Is a PW8 was present when confession of the accused were taken, my lord. PW11, my lord.
that is leading to discovery of that weapon or what
Dora.
Weapon and also the admitting his guy committed the murder.
से admitting
Sir,
छाड़
the
दियो
attack-
सेटा that is not admissible
But
से
as you-
recovery part टा only that will be relevant
रिकवरी रिलेवेंट कारण ये पुलिस कहूची कि मु 2 मास मो पाखा रखी आई एम नॉट सेंड टू द एमओ
leave that we are not on 27 how do you overcome the oral evidence of this witness PW8 and what is the PM report by the way who is the doctor
पीएम रिपोर्टिंग supporting my lord and last time my lord I see
no let us see that
PW4 your
for
lordship.
my lord Olek Mahapatra page 59
vital part of the body रे गोटे फास्ट इंजुरी टा हला नेक रे हला
yes ma'am.
आउ डेप्थ रा देखंतु 3.5 पश्ची भितरु नेक रे 3.5 किछि कम नुहे बुझिले ना तार साइज होची से ने ये 2.5 अछि एटा होची 1 माने एटा भितरु पसिछि डेप्थ होची 3.5 इंच and up to 6 cervical vertebra horizontally at the left side of the lower part of the neck gala next wound is in the long cut wound again that is 3.5 hard wound is on the right shoulder fourth wound is on the mid clavicle end fifth wound is a cut wound intrascapular area sixth wound is on the right deltoid region so that means 6 injuries on different parts of the body has been caused including the neck as well as the lungs and cause of death was due to shock and hemorrhage and it is antemortem in nature and
preferably number 1 and 2.
1 and 2 are the
right
Yes, sir.
preferably most probably on the number 1 and 2 से जोटा नेक रे और लॉन्ग रे and long injury देखो puncture wound लखीची blood clotted was present in the peritoneal space सेटा को देखुची से so with which force you have given that blow in those vital parts of the body after that also there are other injuries also caused
the appellant herself was received injuries my lord
what is that
PW9 your lordship.
PW9 my lord Injury on the neck, one injury on the
wait,
back.
କୋଉଠି କଣ କଣ ଦେଖା
PW10, your lordship, sorry. PW10 is the doctor who has examined.
Just-
73.
wait. Acha, one injury, it is injured is Lochana Bhoi.
She's
No,
the
that
wife
is
of
not.
Banmali, the deceased.
That's not. या ना होची कौन की रुक्मिणी हाँ number 2 that page number 73 para number 2.
Yes,
I
ma'am.
examined Rukmini Mehramin's appellant, right?
Yes, ma'am.
And I found 4 scratch marks on the right and left forearm, anterior swan, so 2-inch into length, simple in nature. 4 scratch marks on the left chest, swan swat. ये जो आंपड़ा आंपड़ी छोटा
And that too, the wife of the deceased has also been has received punctured wound. That means wife has intervened, might be, and she has also received the punctured wound.
ठीक.
And she has stated nothing, my lord, about
All
this
right.
incident.
No, it's all right. We are not going to that. Nobody has
Yes.
convicted you for this assault on this Lochana Bhoi, right?
Yes, ma'am.
Lochana Bhoi is PW
PW
6.
6.
6, yes.
So what she has stated about the occurrence, let us see that. Read it out.
Yes, ma'am. Page 63, I'm reading. Ma'am.
She is an injured also.
Yes. I know accused Rukmini. The deceased is my husband, madam. The occurrence took place year before Shravan last on a Friday at about 7 p.m. I, along with my husband, deceased, went outside for labor work. In the evening, we returned to our house. Sajana called my husband, the deceased, and told him that Panna was quarreling with her and she is removing her from the house. The deceased told that just he was returning from the work and we will decide the matter in the next morning. Sajana told to my husband that she was calling a meeting and requested my husband to go to the meeting. Thereafter, my husband accompanied with Sajana. I also accompanied with them. My husband.
Sajana is PW?
PW
Panna
3 my lord.
PW 3.
Those two sisters married to quarreling. I also accompanied with them. My husband told to Panna Maria, PW 5, that while she was quarreling with her younger sister, Rukmini was also present in the house of Sajana. Rukmini told to the deceased that he is saying to her. Thereafter, Rukmini came from her house, caught hold of my husband. While I was separating the accused hurt me to right arm. I don't know anything about this case.
She received the injury and went.
Then cross-married. I was examined by the police. It is not a fact that I have not stated before the IO that I was going for work along with my husband. And when we returned to our house, Sajana came and told my husband that Panna was quarreling with her and she convened meeting and Sajana requested my husband to go to meeting. It is not a fact that I have not stated before the IO that my husband went to the meeting and I accompanied my husband to the meeting. It is not a fact that I have not stated before the IO that Rukmini came from our house and caught hold my husband. We had gone to work to different places. When I returned from my work, my husband had already returned from his work. Panna had not gone to our house. There was no quarrel at our house or in front of our house. When I went to the house of Panna with my husband, I saw Rukmini, Panna and Sajna were present there. No outsider was present in the house or in front of the house of Panna. When we arrived at the house of Panna, Rukmini went away. Thereafter, Rukmini came and without saying anything, caught hold of the deceased Banmali. When Banmali fell down, Rukmini, the accused, was standing. I have not seen any injury on the part of Rukmini, the accused. I don't know how I sustained injury on my right arm.
So, ଗୋଟେ ଲାଇନ୍ ଖାଲି ଆସିଛି ଏ ଯୋଉ କ୍ରସ୍ ଏକ୍ଜାମିନେସନ ଅଫ PW8 ରୁ ଯେ ଯୋଉ page 68 ରେ that when the accused was standing, the deceased was quarreling with the accused. And there was some kind of quarrel with the accused, and medical examination report indicate that some injuries have been sustained. Of course, it's simple injury. So, the say out line there was tussle. Say tar next line, page 68. There was tussle between the accused and the deceased as the deceased protested to the accused. So
I
this
had not
much.
seen. I had not seen assault made by the deceased accused.
No, that's all right. So a dita line coupled with the injury sustained by you.
Yes.
Can it take away the case within the purview of section 302? Jadi, particularly when
this answer can be taken as sporadic.
From the evidence of PW 11, it seems manner ki the PW is not an eyewitness. The 8. The
8.
8 is
Who has stated?
the IO.
IO kon spotter
He is
thila
not a person.
Na siya kହୁଛି ki ଯେତେବେଳେ confession ହେଲା, this person was present.
He is not an eyewitness. He can't say this. Even if he is
IO ki eyewitness kon ga eyewitness ro version achi eyewitness kohuchanti. Now the defense counsel is to, by way of cross examination, has to demolish, or by other evidence he has to brought on record about the non-presence of that witness at the spot, so that the court can consider. IO kon koibo ki IO is to record the statement. In the 161 statement, is it there that he has not stated anything about the occurrence? Otherwise, it would have been confronted to him. ସେମିତି କିଛି ତ କ୍ରସ୍ ଏକ୍ଜାମିନେସନରେ ଆପଣ ଆଣିନାହାନ୍ତି ଯେ ନାଇଁ ତମେ ଗୋଟେ ପୋଷ୍ଟ ଅକରେନ୍ସ ୱିଟନେସ୍ ଥିଲ ବା ତମର ଏ ବିଷୟରେ କିଛି ଜ୍ଞାନ ନାହିଁ, ତମେ ପୋଲିସ ପାଖରେ କିଛି କହିନ ଘଟଣା ଦେଖିଥିଲ ବୋଲି ପ୍ରଥମ ଥର ପାଇଁ ଆସି କୋର୍ଟରେ କହୁଛ, ଏମିତି ତ କିଛି ଜେରାରେ ନାହିଁ, ଆପଣ ବାହାର କରିନାହାନ୍ତି।
ठीक है सर, PW 11 ଟା आयो
कोनटा କୋଉ ଲାଇନ୍ ଟା କହୁନାହାନ୍ତି?
paragraph 10 minor page 76. During interrogation, she confessed her guilty to have committed murder of Banamani Bhoi and admitted that she has kept the weapon of offense, that is knife, in her house. Accordingly, I arranged witnesses and left her barricade with the witnesses and accused Rukunmar and at her house at 1:30 p.m. She gave recovery of the knife which I seized in presence of witnesses. Therefore, this knife has not been sent to the MO matter. ये जो छुरीटाକୁ से ପଠେଇ ନାହାନ୍ତି, he has kept himself. Page paragraph 23 matter.
No, knife ଗୋଟେ knife seize ହେଇଛି ହେଲା, ଆପଣଙ୍କର submission ହଉଛି କଣ ସେ knife ଟାକୁ ପଠାଇନି ସି please come to page 82. See item number 6.
Page
one knife containing blood stain.
And come to page number 84. See the knife contains blood. Of course, tar origin.
But that blood group is not there, madam.
Blood group is not there, but blood is there. Don't make submission which is not there available. You are whatever you are telling, that is something contrary in the.
No, madam. Paragraph 23 has stated कि I kept the
ନାଇଁ ପରା ଦେଖିଲେ ଆପଣ ତ ଏକ୍ଜିବିଟ୍ ଡି ହିସାବରେ ମାର୍କ ହେଇଛି ଏବଂ କୋର୍ଟ ଥ୍ରୁରେ ପଠା ହେଇଛି, ସି ରିପୋର୍ଟ ମଧ୍ୟ ଆଭେଲେବୁଲ ଅଛି, ନାଇଫ୍ କୁ ଏକ୍ସାମିନ କରିଛନ୍ତି, ନାଇଫ୍ ରେ ବ୍ଲଡ ପାଇଛନ୍ତି। ଅଫ କୋର୍ସ ଇଟ୍ ଇଜ ଟ୍ରୁ ଦ୍ୟାଟ୍ ଇଟ୍ସ ଏ ହ୍ୟୁମାନ ଅରିଜିନ କି ନ ସେଇଟା ପାଇଲେନି, ଗ୍ରୁପ ମଧ୍ୟ କିଛି ଦେଇଲେନି କାରଣ ଡିଟୋରିଏଟ ହେଇଯାଇଥିଲା ତାର କଣ୍ଡିସନଟା ହେଲା, ବଟ୍ ନାଇଫ୍ ହାଜ ବିନ୍ ସିଜ୍ଡ। and ଏଥିରୁ କଣ ଆପଣ ଜାଣିବେ ଯେ he was not an eyewitness? ଏଇ ଯୋଉ ଆଇଓର ଯୋଉ ଲାଇନଟା ଆପଣ ପ୍ଲେସ୍ କଲେ, how far it is relevant to adjudicate that no, PW8 is not an eyewitness to the occurrence?
I'm presuming because confession ପରେ ସେ ଯୋଉ ସେଇଟା ତ ଆଣିନାହାନ୍ତି କ୍ରସ ରେ, କାରଣ ଯୋଉ ଡିଷ୍ଟାନ୍ସ ଟା ଯୋଉ ସେ ଦେଖି ପାରିବନି, it is 100 feet and more minor.
ଆମେ ବର୍ତ୍ତମାନ କଣ ଆଣିନାହାନ୍ତି, ଆମେ କଣ ବର୍ତ୍ତମାନ ପ୍ରିଜ୍ୟୁମ କରିଦବା ଯେ ଯୋଉ ଜାଗାରେ ବସିଥିଲା, ଯୋଉ ଜାଗାରେ ସ୍ପଟ ହେଲା ସେଟା that was not visible, so he could not have marked there that occurrence from the sitting position.
In paragraph 31, after medical exam of the accused, I detained her in the police station till the arrest. It is not a fact that I obtained the confessional statement of the accused by threatening to the accused. I have recorded the confession statement of the accused in the presence of the witness, namely Vidyadhara Sahu and Arakita Bhai. That Vidyadhara Sahu is a PW8 minor. And I obtained the LTI of the accused and signature of the witness. The confession statement is available in the record.
Cross examination से PW8 clearly कहूची जे we saw third line paragraph 5 we saw the occurrence from the place where we were sitting on the veranda of Bhojyo's house ହେଲା ବର୍ତ୍ତମାନ ଆପଣ ଫୋକସ କରିଗଲେ ତାପରେ ଯୋଉ ଜେରା ଗୁଡାକ ହେଲା ସେ ଆକ୍ୟୁଜ୍ଡ ର ଘର ସେ ୱିଟନେସ ର ଘର କୋଉଠି ସେ ତା ଘରଠୁ ସେ ଅନ୍ୟ ଲୋକର ଘର ଏଇଗୁଡାକ ଉପରେ ପ୍ରଶ୍ନ ପଚାରିଲେ କିନ୍ତୁ ମେନ୍ ଯୋଉଟା ପର୍ପସ ଆଣିବା କଥା ସେଟା ଯଦି ସ୍ପଟ ମ୍ୟାପ ରେ ଆଭେଲେବୁଲ ନାହିଁ ସେଟା ଆପଣ ପଚାରିକିନି ବାହାର କରିଥାନ୍ତେ ବା ଆପଣଙ୍କର ଡିଫେନ୍ସ ସଫେଇ ସାକ୍ଷୀ ଦେଇଥାନ୍ତେ ସେ ବିଷୟରେ ଯେ ଭଜ ସାହୁ ବରଣ୍ଡାରେ ବସିଲେ ସେ ସ୍ପଟ ର ଯୋଉ ଜାଗାଟା ସେଟା ଦେଖାଯିବନି
ଗାଁର କିଛି ଲୋକ
କହିଥାନ୍ତେ
whose houses are nearby to the
They have not been examined, madam.
କିଛି ନାହିଁ ପୁରା ଆଉ କିଛି ନାହିଁ
ଆଉ ଗୋଟେ ବି ଡାଉଟ ଗୋଟେ ସ୍ତ୍ରୀ ଲୋକଟା ଗୋଟେ ପୁରୁଷ ଲୋକ ଛୁରୀ ବସିଛି ଇଏ ଦେଖୁଛି but not didn't react, madam.
why everybody will react in the same fashion what you presume
ସିଏ ତାକୁ ଧରି ନେଇଛି ଯେ ମତେ ଇଏ କହୁଛି ଏଇ ଯୋଉ ମିସକନସେପସନ ରେ
motive is not there but ଏଇ କଥା ସାମାନ୍ୟ କଥା
no
see the intensity of injuries
ଯୋଉ ଟାଇପ ର ଇଞ୍ଜୁରି ଆପଣ କରିଛନ୍ତି that itself shows the intention question is that 304 part 1 ରେ ମଧ୍ୟ intention କଥା କହୁଛି but only thing is that if you have to brought a case of 302 to 304 part 1 then you are to prove that it is culpable homicide not amounting to murder that means it comes within any of the 5 exceptions that is enumerated under section 300 ହେଲା ସେଇ ଯୋଉ ପାଞ୍ଚଟା exception ଭିତରେ ଆପଣଙ୍କୁ ଯୋଉ ଦେଖାଗଲା ଏତିକି ଯୋଉ ରହିଛି ଯେ ଗୋଟେ quarrel ହେଲା ଟସଲ ଭିତରେ ଇଏ କିଛି injury ମଧ୍ୟ ପାଇଛି ଏଇ circumstance ରେ ଘଟଣାଟା ହେଇଛି and there is a decisions also no one decision number of decisions are there that in case of grave and sudden provocation who caused the provocation that is immaterial number 1 number 2 how many injuries were caused that is also immaterial that is 89 supreme court
yes ma'am.
so ଏଇଟା ଅଛି ଆପଣଙ୍କର ତେଣୁ ଏଇ ଜିନିଷକୁ ଯଦି କିଛି ହେଇପାରିବ ଅଦରୱାଇଜ ଆଉ କିଛି ବାଟ ଆଦେରେ ନାହିଁ ସେ ଯୋଉ ଇଏଟା ବହିଟା ଅଛି କି 89 ସୁପ୍ରିମ କୋର୍ଟ ଦେଖିଲେ କଣ ସେ ବହିଟା ସେଦିନ ଦେଖିଥିଲୁ ଆଉ ଗୋଟେ କେସ୍ ତା ଦେହରେ ବି ଥିଲା ବୋଧେ ସେ ଯାଇକିନି ଗୋଟେ କଣ ଆଣିକିନି ମାରିଛି
Recent decision is there. I have not gone through, madam. It had a number of injuries.
To invoke exception 4 to section 300, 4 requirements must be satisfied that it was a sudden fight, there was no premeditation, the act was done in a heat of passion, the assailant had not taken any undue advantage or acted in a cruel manner. The cause of quarrel is not relevant, nor it is relevant offered the provocation or started the assault. The number of wounds caused during the occurrence is not a decisive factor. But what is important is that the occurrence must have been sudden and unpremeditated, and the offender must have acted in a fit of anger. Of course, the offender must not have taken any undue advantage or acted in a cruel manner. When on a sudden quarrel, a person in the heat of moment picks up a weapon which is handy and causes injury, one of which proves fatal, he would be entitled to benefit of this exception, provided he has not acted cruelly. Thus, where in a case of quarrel between the deceased and the accused regarding possession of the premises, it was reasonable to infer from the facts that the deceased must have intervened from the side of so and so, and I received the injuries, one of which proved fatal. It's a fact, is something different in nature. But এই ଯୋଉଗୁଡାକ କହୁଛନ୍ତି ଏଗୁଡାକ these are there in that IPC ଟା ଦେଖିଲେ ଏ ଯୋଉ who caused provocation ସେଟା that is there in that section itself, I think 300 ରେ that is in sections exception 4 ର explanation ରେ ସେଟା ଅଛି. It is immaterial in such case which party offers provocation or commits the first assault. Exception 4 टा जो कहला culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden call and without the offender taking undue advantage or acted. এই ল্যাঙ্গুয়েজটাও কোট কলে তারপরে এইটাকে মধ্যে কোট করেছেন সেভেন পার্টি অফার্স provocation or commits the first assault. তাহলে এই কেসটাକୁ আনালাইজ କରନ୍ତୁ piece by piece. କଜିଆ ହଉଥିଲା A and B ଭିତରେ ହେଲା ତ ସେଠି ନା deceased ର କିଛି ରୋଲ ଥିଲା ନା accused ର ରୋଲ ଥିଲା, right? A and B ଭିତରୁ let us say A went and called, okay, called the deceased to intervene, and the deceased came and tried to just settle or whatever it may be to pacify the dispute. ଏଇ ଯୋଉ pacify କଲା ଭିତରେ ଯେ କାହିଁକି ତମେ ଅନ୍ୟ ଲୋକର କଥାରେ ପଡି କଳି କରୁଛ ତମେ ଦି ଭଉଣୀ ଭିତରେ ପଡିବ ନା. The appellant was sitting there, the appellant who was present there, he took it as an exception and thought that perhaps the deceased was hinting at him or him. ନାଇଁ ହଁ ଏଇଆକୁ ନେଇ ସେ ଘର ଭିତରକୁ ଯାଇଛି, ଘର ଭିତରକୁ ଯାଇକିନି weapon ଟେ ଆଣିଛି, weapon ଟା ଆଣିକିନି then as it appears there was some kind of tussle, କାରଣ evidence ମଧ୍ୟ ଆସୁଛି PW8 ର tussle ହେଇଛି, tussle ଭିତରେ ତାକୁ ବୋଧେ କିଛି ଆମ୍ପୁଡା ଆମ୍ପୁଡି ମଧ୍ୟ କରିଛି କାରଣ ଯୋଉଗୁଡାକ ସବୁ injury ସିଏ receive କରିଛି as per the evidence of that PW10 scratch marks ଗୁଡାକ ତାର different body part ରେ like chest ରେ ରହିଛି ଆଉ forearm ରେ ରହିଛି, ଏଇ ସବୁ part ରେ ତାର injuries ଗୁଡାକ ରହିଛି, ତେଣୁ ସେଇ ଯୋଉ scratch mark ଥିଲା ଭିତରେ ତାପରେ ସେ assault କରିଛି. ତ ଏଇ ଯୋଉ case ଟା ଆମେ ଇଏ କରୁଛୁ that's a different matter but some kind of proposition is there. So have you brought any decision almost peaceful intervener ହେଇଥିବ ଏଇ type ର ଗୋଟେ befitting case ଯୋଉଠି ହେଇଥିବ ତାକୁ ଆଣିଛନ୍ତି କିଛି?
No, right now no, but
right now କଣ ଆପଣ ତ ଆର୍ଜନ କଲୁ ଆଉ କଣ ପାଇଁ ଆର୍ଜନ?
In fact, that was the reason why I did it.
କାଲକେ ରହିବା ମୁଁ ସେଇ ଖାଲି ସେ ଦିଟା ଦେଇଦେବି ଏଇ ଲାଇଟ୍ରେ
ଆପଣଙ୍କୁ ଗୋଟେ ଟାଇମ୍ ଦିଆହେଲା, ସଫିସିଏଣ୍ଟ ଟାଇମ୍ ଆପଣଙ୍କୁ ଦିଆହେଇଛି, ଆପଣ ଖୋଜିବେନି ଡିସିସନଟା, ଆପଣ ଯେତେ ଆନାଲାଇଜ କରିବେ ଇଏ କରିକିନି ସେ ଜେଲ୍ କ୍ରିମିନାଲ ଅପିଲ ଲେଡି ଆପଣଙ୍କୁ ଇଣ୍ଟରେଷ୍ଟ କରାହେଇଛି, ସୋ ବେଷ୍ଟ ଆପଣ ଚେଷ୍ଟା କରିବେ ଯଦି କିଛି ପସିବଲ ହେଇପାରିବ ଇନ୍ ଆକର୍ଡାନ୍ସ ୱିଥ୍ ଲ, of course, whether any relief can be granted in such a situation. She must have remained in custody for how many years?
Yes, 20 years.
20 years. Well, ଅନୁପାତ୍ରରେ ଆପଣ ଏଇ ଡିସିସନଟାକୁ ଫିଟ୍ କରେଇଦେବେ। 89 ସୁପ୍ରିମ କୋର୍ଟ 1094 ଆगे ବାହାର କରିଦେବେ। ଆପଣ ମାରିବେ relied on, relied on ଦେଖିବେ number of decisions it has been relied on, including our high court. ମୁଁ ତ 3-4ଟା କେସରେ ରିଲାଏ କରିକି ନେଇଛି କେସ୍ 304 part 1 କରିକି ହେଲା, and the reported decisions also ହେଲା, କାରଣ ଏଠି ଯଦି ଇଏ କରନ୍ତୁ ଆପଣ ଆଟେମ୍ପ୍ଟ ସେ ଚେଷ୍ଟା କରିବା କଥା, ଆପଣ ପିସଫୁଲ ଇଣ୍ଟରଭେନର ମଧ୍ୟ ପାଇବେ ଏଠି ଯଦି ବହୁତ ଡିସିସନ ଅଛି। ଆକ୍ୟୁଜ୍ଡ ର ଦେଖନ୍ତୁ ଏଠି ଆପେଲାଣ୍ଟ ର obviously କିଛି ପ୍ରି ମେଡିଟେସନ ନାହିଁ, ତାର ସେ ଗାଁ ଲୋକ ତାଙ୍କ ସାଙ୍ଗରେ କଣ ତାର ଇଏ ଅଛି, କିନ୍ତୁ ସିଏ କାହିଁକି ଏକ୍ସେପସନ ହେଲା, ସେ ଗୋଟେ ମିସକନସେପସନ ରେ ଏକ୍ସେପସନ ନେଇଛି ଯେ ପରହାପ୍ସ ସେମାନେ ଏଇ ଯୋଉ ଇଏ ଆସିକି ଯୋଉ ତାଙ୍କୁ କହୁଛି ଯେ ସିଏ କହୁଛି ବୋଧେ ମୋରି ଯୋଗୁ ଇଏ କଳି ହଉଛି ତାଙ୍କ ଭିତରେ, ତେଣୁ ବାହାର ଲୋକଙ୍କ କଥାରେ ଏଇ ଲାଙ୍ଗୁଏଜ ଅଛି ନା ୟୁଜ ହେଇଛି, ତମେ ବାହାର ଲୋକଙ୍କ କଥାରେ ପଡି କାହିଁ ତମେ ଦି ଭଉଣୀ କଳି କରୁଛ, ଦିସ୍ ଇଜ ଦି, ସିଏ ଭାବିଲା ଏଇ ଯୋଉ ବାହାର ଲୋକମାନେ ସିଏ ବୋଧେ ମତେ ମିନ୍ କରୁଛି ଆଉ ମତେ କହୁଛି ବୋଧେ ମୁଁ ତାଙ୍କ ଭିତରେ କଳି ଲଗଉଛି, ଏଇଟାକୁ ତା ମୁଣ୍ଡରେ ପଶିଲା, ତାପରେ ଦେयर ୱାଜ ସମ କାଇଣ୍ଡ ଅଫ ୱାଲ, ତାପରେ ସିଏ ବୋଧେ ଧସ୍ତା ଧସ୍ତି ହେଇଛି ଯୋଉଟା ଆସଲ୍ଟ ମଧ୍ୟ ଅଛି ଯେ, ତେଣୁ ତାକୁ ଆମ୍ପୁଡା ମଧ୍ୟ କରିଛି, ତାପରେ ଏଇ ଅକରାନ୍ସ ହେଇଛି। ସ୍କ୍ରାଚ୍ ଇଞ୍ଜୁରି ଗୁଡା ଚେଷ୍ଟ ରେ ଅଛି ଆଉ ଏଠି ବି ଅଛି, ସେ ଆମ୍ପୁଡା ଗୁଡାକ ସ୍କ୍ରାଚ୍ ଇଞ୍ଜୁରି ବୋଧେ। ସେକେଣ୍ଡ ହଉଛି ଚେଷ୍ଟ ରେ ଅଛି,
just 1 inch in left side chest.
prosecution କିଛି explain କରିନି, but again these injuries are not that serious that merely because it is not explained that can be a ground for this right of private defense, etc. That of course you have not taken also. So it can be taken into consideration even if no specific plea is taken, like consent in a rape case, right of private defense in a case of 302. It can be taken even the specific plea is not taken if it is otherwise available from the record. So ଏଠି କିନ୍ତୁ ଆପଣଙ୍କର ସ୍କ୍ରାଚ୍ ଇଞ୍ଜୁରି ଗୁଡାକ ଖାଲି ଅଛି, ଆଉ ଏଇଟା ଟିକେ ବାହାର କଲେ ଏଠୁ ଏଠି ଆସ, ଏଇଟା sir. Right. And here. And where is the law? Vascular Surendra Kumar versus Swanson mentioned in then decision of the Supreme Court. So many କେତେ ଜାଗାରେ rely ହେଇଛି ଓଡ଼ିଶାର 12ଟା କେସରେ rely ହେଇଛି decision. This is of court a decision now. ଗୋଟେ ଇଏ ମଧ୍ୟ rely କରୁଛି ମୋର ମନେ ପଡୁଛି ଜଷ୍ଟିସ୍ R.K. Patra and maybe ବାଲେଶ୍ୱର maybe this case is not dated by 96 percent everything. The analysis for some then in Pataxe. Already there was provocations on the side at the line is nice.
Age of the appellant then?
35 marriage.
Huh?
35. 35 to 40, almost same age. And I made a wrong submission, ma'am. As per the record, she is staying in her house, ma'am. The appellant is staying in her house.
She has been released on bail.
Yes.
When he was granted bail? ଏଠି ଆମେ ଲେଖିଛୁ ମାନେ his model police station report ଟା ମଧ୍ୟ ଆସିଥିଲା ଯେ she is alive, right? So your submission that she is in custody for 20 years not correct.
Yes.
ଆପଣ କେମିତି submission କରୁଛନ୍ତି, କେମିତି ଯାହା ନାହିଁ ତା ଗୋଟେ କହି ଦଉଛନ୍ତି କେମିତି? ପ୍ରାକ୍ଟିସ କରୁଛନ୍ତି ହାଇକୋର୍ଟରେ, ବେଲ୍ ଅର୍ଡର ହେଇଛି ତାକୁ 28/11/2011 ତାର ବେଲ୍ ଅର୍ଡର ହେଇଛି. That means she has spent only 5 to 6 years.
At best, in between, if she has not been released again.
ଘଟଣାଟା ହଉଛି 2003 ର 18/7/2003 ର FIR. So maximum ହେଇକିନି ଯଦି ବି ଟ୍ରାଏଲ ଷ୍ଟେଜରେ we do not know.
ନଥିବ, yes.
ଟ୍ରାଏଲ ର ବ୍ୟବହାର କଲେ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡଟା LCR ଟା ବାହାର କଲେ order sheet. Accused is present. ତାମାନେ ସେତେବେଳେ ବି ବେଲ୍ ରେ ଥିଲା. କଣ ଆପଣ କହୁଛନ୍ତି?
She was on bail also. ଯାଇନି ଭିତରକୁ.
Yes, is accused is ତାପରେ ଗୋଟେ ଷ୍ଟେଜ ରେ ସେ absent ରହିଥିଲା. Absent ରେ ତାପରେ ତାପରେ ବୋଧେ ତାକୁ ଆରେଷ୍ଟ କରାଯାଇଛି. ତାପରେ କାରଣ ରିମାଣ୍ଡ ଦେଖୁଛି କଷ୍ଟଡି କୁ.
Accused is absent on call in 2004.
ତାପରେ ଏଇ ଯୋଉ 2004 ର ସେପ୍ଟେମ୍ବର ମାସରେ ଦେଖଉଛି ଯେ accused is produced ବୋଲି. ତେଣୁ
absent as promised, she could not be produced in custody.
अच्छा.
2004.
There is no bail order.
Examined. Is it produced?
Produced for the produced in
When the letter was issued to Honorable Chief Justice for this criminal appeal, it is stated that she is now staying at the Nari Bandhu Niketan, Sambalpur.
See, that is a different matter, but the order sheet at least reveals that she has been released on bail by this court. And no, she was not on. He was not on bail.
In 2004, the matter has come, and in 2005, judgment is there. So within 1 year.
ତାପରେ ହାଇକୋର୍ଟ ରୁ ବେଲ୍ ଯାଇଛି 2011 ରେ. So maximum ତାର final form ରେ ଜଣା ପଡିଯିବ date of custody. Order sheet. Final form, yes. Right. So 19/7/2003 is the date when she was forwarded to. 19/7/2003 ରୁ High Court ରେ ଯଦି ବେଲ୍ ଗଲା ଜେଲ୍ କ୍ରିମିନାଲ appeal ରେ ଏଠି ଗଲା 11 ରେ. Right, 28/11/2011 ରେ ବେଲ୍ ହେଲା. So 8 years some months.
4 months.
Misconception. ये 93, 90, 90. I still remember matter was arguing for number 5. Which is RK Park and Patna was there. 93, 90, 90. Because another matter also was 93 for 93 to 95. The matter মানে কোর্টে আর্গুমেন্ট করা হয়েছে সে মনে রয়েছে পাইলাম হোশিয়ার কোর্ট অফ দৌজ দিয়ে 95 টা দিয়ে 95, 90 ତ ବୋଧେ ଦିଟା ଭଲ୍ୟୁମ ହେଇଯାଇଥିଲା 95 ରେ ବୋଧେ ଦିଟା ଭଲ୍ୟୁମ ହେଇଥିଲା 94 ପର୍ଯ୍ୟନ୍ତ ବୋଧେ ଗୋଟେ ଭଲ୍ୟୁମ ଥିଲା ନା Here 98 adi. 94 adi. 6 adi kaana. 696. JCRL number 151 of 2005.
Would you like to say something, Mr.
Yes, Your
Mishra?
Lordship. Right. Some aspects have not been placed before Your Lordship.
Yes.
Lords, PW 2 and 3, although they have turned hostile, they have still stated about their auricular version of the witnesses, Your Lordship. They have heard the whole incident, Your Lordship. That is what they have stated, Your Lordship. If Your Lordship may take PW 2 and 3, both of them have categorically stated that we heard the shout of Bonamali, that is the deceased, shouting that Rukmani is stabbing me. So even though they have turned hostile, they finally, their auricular versions has to be taken into account, my lords. That is one aspect, Your Lordship. Now, my lords, one more aspect is that there were blood patches found on the apparels of the deceased, I mean of the accused, which have been identified to be of human origin. Those blood patches.
Sari.
In the sari, yes. Now, Lordship, the injury that the accused has sustained, as per PW 10, are very mild and very simple in nature, most likely caused by scratch wounds which the deceased must have given, perhaps while defending himself, while he was getting stabbed. So, Lordship, those blood patches of human origin cannot come from 4 simple scratch injuries on the chest and on the arm. Because, my lords, I verified from Modi's book, Your Lordship, on the chapters on abrasions, where it has stated, if I may just read the relevant line, abrasions vary in size and shape and bleed very slightly. So if someone is bleeding very slightly, it is very unlikely that the blood patches will sustain for such a long period of time and will be identified to be of human origin after a lapse of 2 months. That is my humble submission, Your Lordship. And so far as the part of grave and sudden provocation is concerned, Your Lordship, here my submission is that the accused has in fact taken undue advantage and has in fact acted in a cruel manner, because she has stabbed the victim 6 times. If it was just once out of a fit of anger, it would have been how a reasonable person would have reacted. Because in Nanavati's judgment, it was held that to pass the first test, that is whether the provocation is not sought or voluntarily provoked by the offender as an excuse for killing and doing harm to any
No,
person.
Mr. Mishra, there is
Lordship.
a line, this decision which we are facing,
Lordship.
that number of injuries caused is not the criteria. It is caused provocation. Again, let us say, uh, when so and so is there, right, the cause of quarrel is not relevant. One, the nor it is relevant who offered provocation. Number two, or started assault. Number three, the number of wounds caused during the occurrence is not the decisive factor. What is important is that the occurrence must have sudden and unpremeditated, and the offender must have acted in a fit of anger. এই তিনটাକୁ ଆମେ harp করছু. Can you say the background of the case as we have pointed out? It is there. A and B was quarreling.
Yes.
Neither the deceased has anything to do with that quarrel, nor the appellant has anything to do with that quarrel, right? Because of one of the party to the quarrel went and called the deceased, okay, and the deceased also came on his request to pacify the dispute or the quarrel, and during such pacifying while quarrel, he perhaps stated that why are the other instance of others, ହେଲା ଆପଣ ଦି ଭଉଣୀ ଅନ୍ୟ କଥାରେ ପଡି କାହିଁକି କଳି କରୁଛନ୍ତି? The appellant was there and he thought that perhaps the deceased was hinting at him. ଏଇ ଜିନିଷଟାକୁ ସିଏ ଏକ୍ସେପସନ ନେଇଛି, ନେଲା ପରେ obviously ଚ୍ୟାଲେଞ୍ଜ କରିଥିବ, ତାଙ୍କ ଭିତରେ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ମଧ୍ୟ ଆସୁଛି there was tussle between the deceased and the appellant. ତାପରେ ସ୍କ୍ରାଚ ମାର୍କ ଅଛି ଏବଂ ତାପରେ ଆସଲ୍ଟଟା ହେଇଛି. ଏଇ ସିଚୁଏସନରେ ଆସିଲେ ଏଠି ଯୋଉ ଏଇ ଯୋଉ ଲାଇନଟା particularly ଆସିଲା that what is important, the occurrence must have taken in a sudden and unpremeditated manner. ହେଲା, ଏଠି ସେ assault ଆଗରୁ କରିବାକୁ କିଛି premeditation of mind ଥିଲା କି appellant ର? ତାକୁ ମାରିବା ପାଇଁ appellant ତ spot ରେ ନଥିଲା, କଳି ବି ନଥିଲା ତା ଭିତରେ, ୟାର ପ୍ରିମେଡିଟେସନ ନଥିଲା. ଅକରେନ୍ସ ଟା ସଡନ ହେଲା ନା ନାହିଁ? ସେ ବସିଛି ଏମିତି କଳି ହେଲା ଦି ଭଉଣୀଙ୍କ ଭିତରେ, ଇଏ ଗଲା ତାକୁ ଡାକିଲା, ସିଏ ଆସିଲା ବୁଝେଇଲା, ଗୋଟେ ସଡନ ହେଲା. ତ ସଡନ ବି ଅଛି, ଅନପ୍ରିମେଡିଟେଟେଡ ବି ଅଛି. ତାପରେ ସେ ଯୋଉ ଏକ୍ସେପସନ ନାହିଁ, ଇନ ଏ ଫିଟ୍ ଅଫ ଆଙ୍ଗର କାହିଁକି ହେଲା ନା, ସେ ମିସକନସେପସନରେ ନେଇଛି ଯେ ମତେ ବୋଧେ ଇଏ କହୁଛି ଏମ କରିକିନି, ତେଣୁ ସେ ଫିଟ୍ ଅଫ ଆଙ୍ଗରକୁ ଆସିକିନି, then there is also some material that he has also received some injury, maybe simple, you are right, simple injuries on the chest and on ei background re assault ta heichi.
But there is intention.
There is intention
Because the manner in which he
right
stabbed, so intention is there.
ତେଣୁ ଏଠି ଯୋଉ କ୍ରାଇଟେରିଆ ରହୁଛି, one of the criteria that it should be during quarrel, unpremeditated, fit of anger, ସେଇ ଷ୍ଟେଜ ରେ assault ଟା ହେଇଛି. ଆଉ ଏଠି ଅନେବଲ ସୁପ୍ରିମ କୋର୍ଟ କହୁଛନ୍ତି କିଏ assault ଷ୍ଟାର୍ଟ କଲା, that is irrelevant, ହେଲା, ଏବଂ whether କିଏ ଆଉ ଗୋଟେ ହେଲା କଣ,
number of injuries,
who caused provocation and who started assault, that is immaterial, and number of wounds is also immaterial. এই যদি ইয়েକୁ କରାଯାଏ ତାହେଲେ whether it would come within that ambit of that 304 part 1. Part 1 he also deals with that intention part.
because she has acted in cruelty.
Now, my humble submission is that the one of the tests is that the accused should have lost all sense of self-control. Now, the self-control test, Lordship, it has been verified. It has been categorically stated in many judgments that it will be taken vis-a-vis how a reasonable person would react in such a situation. Now, my lords, we don't know the exactly what was the dispute between the two sisters. We only know that the third party, who was the accused, somehow got offended because she thought that the
She is
victim
being
was
indicated.
yes, she is being implicated in a way or another. So, my lords, my humble submission is that even though they are rustic villages, this would not tantamount to a reasonable person's reaction, your lordship. Because had it been a lathi or some other weapon which is not as fatal as a knife, my humble submission is it would have amounted to a reasonable reaction which a reasonable person would have given. But bringing a knife from the house, from her ura, and assaulting and standing there, and the victim protested the action, because of that the tussle occurred. That is the version of PW 8 as well. So, Lordship, the provocation part can also be divided into two parts here. First is when she thought that it was her, the fingers were pointed at her, and the second is that when she came out with a knife, the victim protested because she was in such a situation. So, Lordship, my humble submission is that it is not a reasonable reaction to pass the test of control.
That is all right, but it is not premeditated.
Yes, it is not premeditated.
Because she has gone inside the home. It's not that she was keeping the knife with her.
Premeditated नुहे एवं sudden मध्य हला एटा मध्य जो requirement of that particular exception 4 रो जो रहुची से दीटा भीतर आसुची जे एवं he was not a party to the quarrel. He just thought otherwise that मते बोधे ये indicate करुची तेणु सेही याको misconception नेइकिनी से peaceful intervener को assault है.
And it is not that the appellant could presume the deceased to be there at that particular time.
Yes,
it was
that
not
also.
there. So it
I
is
do
just
not,
a
Deceased
situation.
संगरे भी तार किछि previously enmity थिला.
That is also
तार
not been
that
established.
is not there.
Not there. But my only humble submission is that much. The test of control, your lordships, the test of control is not satisfied here, because that is
Again, you
not.
are to say that in what background this person, what is the education, all
Yes.
these things are to be care.
Yes, that is.
ତେଣୁ self control ଆଉ ଜଣେ reasonableness ଜଣେ educated person ବା ଯାହାର ଇଏ ଥିବ ସେ ଯୋଉ type ର ଆସିବ ଗାଁରେ ordinarily ଛୋଟ ଛୋଟ କଥାକୁ ମଧ୍ୟ ନେଇକିନି ପାଟିତୁଣ୍ଡ ହେଇକିନି ବହୁତ aggravate ହେଇଯାଏ situation ରେ ତେଣୁ of course now the situation has changed both say yoga pranayam ଅନ୍ୟାନ୍ୟ ସେ ବହୁତ ସେମାନେ update ହଉଛନ୍ତି, that's a different matter, but think of a situation, it's in 2003 ତେଣୁ ଗୋଟେ rural background ରେ ହେଇଛି ଯୋଉଠି ଏଇ type ର situation ରେ ତେଣୁ ସେଠି କୁହାଯାଇ ପାରିବନି ଯେ ସିଏ ତା ନିଜ ଉପରେ control କରିବାର ଥିଲା, ସିଏ ତ particular ଯଦି ଚୁପ ହେଇ ବସିଥାନ୍ତା ଯେ ये कौन ପାଇଁ ତାକୁ exception କୁ ନେଲା, ସେ ତ ନା ଧରୁଥିଲା କି ତାର ଯେ ଇଏ କାଇଁ exception, ଏଇ ଯୋଉ these are all hypothesis ଯେ ଏମିତି ହେଇଥିଲେ ଏମିତି ହେଇଥାନ୍ତା, but something has happened, he took it, ତା ନିଜେ ଭାବିଲା ବୋଧେ ଇଏ କରୁଛି ଏବଂ ନିଜେ ଭାବିଲା ପରେ quarrel ହେଇଛି, ଆପଣ କେସ୍ ନୁହଁ ତାପରେ ଆଉ କିଛି reaction ନଥାନ୍ତା, ତାପରେ କଳି ମଧ୍ୟ ହେଇଛି, କଳି ହେଲା ପରେ ତାକୁ ମଧ୍ୟ some kind of injuries he has received, that is your prosecution witness has also proved. Maybe simple injuries,
That
but
injury caused by head and blood wound.
but some kind of injuries caused thereafter this incident.
Sir.
Yeah. The appellant Rukmini alias Shamren Meher Chamaren Meher faced trial in the court of Lenant ad hoc additional sessions judge FT, Padampur in ST case number 58 of 2004 for offense punishable under Section 302 of the Indian Penal Code on the accusation that on 18/7/2003 at about 8 p.m. at village Barikel, she committed murder of one Bonomari Bhoi bracketry hereafter the deceased. The Lenin trial court by impugned judgment and order dated 36/2005 found the appellant guilty under the offense charge and sentenced him to undergo imprisonment for life. The prosecution case, insert as per the first information report lodged by Ashok Kumar Sahu bracketry PW1 before the
ISC Padampur PS.
officer in charge of Padampur police station is that on that day at about 8 p.m. while he was in his house, one Arakhita Bhui came and informed him that the appellant had stabbed the deceased with a knife and the deceased was lying in a bleeding condition on the road. Immediately, PW1 rushed to the spot and found the deceased was lying full of blood and he was in severe pain. And immediately the deceased was shifted to Padmampur Hospital for treatment in a vehicle. But the doctor examined the deceased and declared him dead. Whereafter the FIR was lodged. PW11 Birendra Kumar Naik, Sub-Inspector Police was the OIC of Padmampur Police Station. After registration of Padmampur PS case number 72 dated 18/7/2003 under section 302 of the Indian Penal Code against the appellant on the basis of the written report presented by PW1 took up investigation of the case. During course of investigation, he examined the informant and sent the constables and arranged for the guarding the dead body of the deceased, and came to SD hospital and also examined the widow of the deceased, namely Lochana Bhoi, bracket PW6, and issued injury requisition for her medical examination. And on the same night, he came to the spot and directed the home guards to guard the spot. He prepared the spot map, bracket exhibit 9, collected Plostin earth and sample earth from the spot, and seized it as per seizure list exhibit 5. The appellant was arrested on the very night, and she was also sent to SD hospital for her medical examination. And some more witnesses were examined by the IO during that night. On the next day, that is on 19/7/2003, the IO came to SD Hospital, Padmampur, where the inquest over the dead body was conducted, and the inquest report, Exhibit 6, was prepared. And after the inquest, the dead body was sent for post-mortem examination, and the IO then the appellant, while in custody of the investigating officer, confessed his guilt, and on the basis of his statement, he led the police party and gave recovery of the weapon of offense, that is knife, from her house, which was seized as per seizure list exhibit 4 in presence of the witnesses. The wearing apparels of the appellant were also seized on her production as per seizure list exhibit 11, and the appellant was forwarded to the court. After post-mortem examination, the constable produced the wearing apparels of the deceased before the IO, which were seized as per seizure list exhibit 3. The IO also received the injury report of PW6, so also the appellant, and he also received the post-mortem examination report, made a prayer to the learned SDGM Padmampur for sending the exhibits for chemical examination, and accordingly the exhibits were sent for chemical examination, and the chemical examination report by exhibit 13 was received by the IO from RFSL Sambalpur, and on completion of investigation, PW 11 submitted charge sheet under section 302 of the Indian Penal Code against the appellant. After submission of charge sheet, case was committed to the Court of Session, complying the procedure, where the London Trial Court framed charge as aforesaid against the appellant, to which the appellant pleaded not guilty and claimed to be tried, and therefore the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined as many as 11 witnesses. The prosecution also proved 13 exhibits detailed and two material objects, that is MO1 is the knife and MO2, three material objects. 2 is the lungi and 3 is the towel. MO3 is the towel. The defense plea of the appellant is one of denial. The London Trial Court, after assessing the oral as well as documentary evidence, came to hold that the prosecution has proved that the death of the deceased is homicidal in nature, and the injuries found on the body of the deceased are antemortem and sufficient to cause death. The London Trial Court then analyzed the evidence of the witnesses, examined on behalf of the prosecution, and held PW1 to be a post-occurrence witness, and held that the evidence of PW2 is not reliable the evidence of PW3 that the deceased Banamali shouted that the appellant had stabbed him was accepted by the London Trial Court. No reliance was placed on the evidence of PW5, as he has not supported the prosecution case. The evidence of PW6 that he was separating the appellant, while he was separating the appellant hurt her on her right arm was also accepted. The Lennon trial court, after analyzing the evidence of the eyewitness PW8, came to hold that the evidence of that his evidence appears to be trustworthy, reliable, and there was no reason to disbelieve his evidence. The court further held that the oral evidence of PW8 considered along with the medical evidence leaves no room to entertain doubt on the prosecution case. No importance was attached to the non-examination of Orokhita, who was sitting with PW8 at the time of occurrence on the veranda of S.K.SAHOO. The Lennon trial court also accepted the prosecution evidence relating to the recovery of knife at the instance of the appellant. It further held that though the appellant has sustained injuries, but since the injuries are simple in nature, non-explanation of the injury on the appellant is not fatal to the prosecution case. It was further held that the seizure of articles during investigation gives support to the prosecution case. The court held that the chemical examination report is neither helpful to the prosecution nor to the accused. And even though no blood opinion or group was found on the knife, was given in respect of the knife, it cannot discredit the prosecution case when the prosecution case is proved. The Lennon trial court further held that the prosecution has proved the intention of the appellant to kill the deceased. And from the evidence of the witness, it is proved that the appellant inflicted repeated knife blows to the deceased, which clearly indicates that she had the intention to kill the deceased. Ultimately, it was held that the prosecution has been able to prove beyond all reasonable doubt that the appellant committed the murder of the deceased and accordingly convicted her under section 302 of the Indian Penal Code. Mr. Satyanarayan Mishra, bracketary 4, Land Counsel, appearing for the appellant, contended that though the prosecution case is that PW8 was sitting on the veranda of one S.K.SAHOO with Arakita Bhoi and saw the occurrence, but the said Arakita Bhoi has not been examined. He further argued that PW6, the widow of the deceased, was also present at the spot and she stated to have received injury on her person, but she has not stated about the appellant assaulting the deceased. The Lennon Council further submits that from the seating position of the PW8, the spot would not be visible and it was during the occurrence took place during the night, and it cannot be said that PW8 person is absolutely reliable and truthful, and therefore the Lennon trial court should not have placed implicit reliance on his version to convict the appellant. Land Counsel submitted that though it is the prosecution case that one knife, which is stated to be the weapon of offense, was seized at the instance of the appellant, but the C report indicates that the origin and the group of the blood noticed on the knife could not be detected, and therefore such seizure is no way relevant so far as the complicity of the appellant in the crime in question is concerned. It was further argued that the background of the case is such which indicates that the occurrence was premeditated one and it took place all on a sudden when the appellant thought that the peaceful intervener, bracket were deceased, was hinting at him while dissuading the two sisters, that is PW3 and PW5, from quarreling with each other. And therefore, in a grave and sudden provocation, she has acted, and since uh, in a fit of anger, after receiving during course of tussle, she has assaulted the appellant, comma, it cannot be said that the complicity of the appellant would come within the purview of section 302 of the Indian Penal Code, and it may at best be a case under section 304 part 1 of the Indian Penal Code. The Learned Counsel further argued that the appellant was taken into judicial custody in connection with the case on 19/7/2003, and he was not released on bail during trial, and during pendency of this appeal, he was released on bail on 28/11/2011. And since more than 20 years have passed the date of occurrence, from the date of occurrence, and the petitioner is a lady, the if this court finds the appellant guilty under section 304 part 1, the sentence be reduced to period already undergone. Mr. Shonak Misra and Additional Standing Counsel, appearing for the state of Odisha, on the other hand, supported the impugned judgment and contended that the doctor bracket ray PW4 has noticed a number of cut injuries on different parts of the body, including the neck and long portion. And he has stated that the cause of death was on account of injury to the neck and lungs, and the injuries were found to be antemortem in nature, and the homicidal death of the deceased is not disputed. Further submits that the manner in which the appellant has assaulted the deceased with a knife is vividly stated by the PW8, and her evidence has not at all been shaken in the cross-examination. The Learned Counsel further submits that merely because the Arkhita Bhoi was sitting with PW8 on the veranda of Bhojosau was not examined by the prosecution, the same cannot be a ground to disbelieve the evidence of PW8. He further argued that PW6, the widow of the deceased, has seen a part of the occurrence and left the spot, and thereafter the main assault on the deceased had taken place, and therefore it cannot be said that the evidence of PW6 in any manner affects the evidence of PW8. Placing the evidence of the PW uh, who evidence ଗୋଟେ ପ୍ରେସ୍ କରିଥିଲେ ଆପଣ 2 ନା PW2 ତ hostile ହେଇଗଲା କୋଉ ପର୍ସନ ଟା ପ୍ଲେସ୍ କରୁଥିଲେ
2 and 3.
ହଁ କୋଉ ଗୋଟେ ପ୍ଲେସ୍ କରୁଥିଲେ ମିଷ୍ଟର ମିଶ୍ର ତାର ଏଭିଡେନ୍ସ ଗୁଡା ପ୍ଲେସ୍
2
କରୁଥିଲେ
and 3, no?
2 and 3, they've heard it.
ହଁ ହଁ ଓକେ ନାଇଁ 3 ଟା mainly କହୁଛି PW3 he argued that
The person who is there in the free.
he had seen the appellant went to her house and brought a knife. No, it a Bonamadi, the deceased told that as to why they were calling at that time.
It's part of the occurrence.
As a scene, a part of the occurrence. And it corroborates the version of PW8. The recovery of knife at the instance of the appellant from her house is another circumstance against the appellant, and bloodstain was also found, and therefore the Lennon the Lennon Council further submits that since the appellant acted in a cruel manner, and even though she was not a party to the quarrel, she dealt repeated blows, the taking undue advantage. Her case would not come within the purview of Section 304, Part 1 of the Indian Penal Code, and the Lennon Trial Court is quite justified in holding the appellant guilty under Section 302 of the Indian Penal Code. Adverting to the contention raised by the Lennon Council for both the parties, let us first analyze the evidence on record as to how far the prosecution has succeeded in proving that the deceased met with a homicidal death. Not only the postmortem report indicates the injuries sustained by the deceased, but also PW4, the doctor who conducted postmortem examination over the dead body of the deceased on 19/7/2003 has stated to have noticed the following injuries, quote these injuries, and he specifically stated that the cause of death was due to shock and hemorrhage, and it was caused due to antemortem injuries, preferably injury number 1 and 2. The doctor further stated that the wounds are possible by sharp cutting weapon. And he has proved his report, Exhibit 2. It is correct that even though at the instance of the appellant, the weapon of offense MO1 was seized, but the same was not sent to the doctor conducting post-mortem examination for obtaining his opinion as to whether the injuries found on the person of the deceased were possible by MO1 or not. But all the same, that cannot be a factor for us to disbelieve the prosecution evidence. And in view of the available materials on record, we found that the Lennon trial court is quite justified in arriving at a conclusion that the deceased met with a homicidal death. The so far as the assault part on the deceased is concerned, three witnesses about the occurrence is concerned. Three witnesses have stated about the same, and they are PW3, PW6, and PW8. Na tini jana koichan na ghatana bisare.
Yes, Your Lordship.
PW3, PW6, and PW8. PW3 has stated that the deceased was his nephew, and Pana Bariya, is his elder sister, and since Pana Bariya quarreled with her, she went to the house of the deceased and brought him to the house of Pana Bariya, who asked Pana Bariya as to why he was quarreling with PW3. And then he left the house of Pana Bariya. When the deceased was telling Pana Bariya about the quarrel, at that time the appellant was sitting on the veranda of their house, and the appellant went into her house, brought a knife, and in that knife she stabbed the deceased 2 to 3 times on her belly, for which the deceased shouted that the appellant had stabbed him, and so saying he fell down on the ground, and the deceased sustained bleeding injuries. This witness, Mr. Just placed paragraph number 7. of this PW3?
When Bonamali was talking with Pana, he had not talked with Rukmini. Rukmini also went to her house without saying anything to the deceased. After Rukmini, the accused, went to her house, I had not seen Rukmini come.
Came
Rukmini
to our house.
came to our house. After Rukmini, the accused went. After Rukmini, the accused went to her house.
After Rukmini, mane the appellant.
Appellant.
Yes. After Rukmini, the accused
went to her house.
Bonamari, the deceased,
came out from our house.
Came out from our house. Yes. Bonamari is the deceased, right?
Yes.
When Bonamari go out from her house, we the two sister had not come out from her house. तापर आमे दी जनो भौणी घरु बाहरिलु नाही. बुझिले ना? After hearing shout, we came out of our house and I found Bonamari the deceased was lying dead. How she can be an eyewitness to the occurrence?
No, she has been. There is a contradiction. She has been disbelieved.
No, ये जो कहला चीफ रे कहला ना जो तीनटा ब्लो देला से कहला नहीं कि चीफ रे देखंतु आपण.
Yes.
Chief रे कहला जे brought that knife and in that knife accused stabbed the Bonamari to 2 to 3 times.
Yes.
By that knife. ये जो evidence टा से कहला, if we go through this paragraph 7 and 8, we found that it is just something else that perhaps he has not seen the.
No, that is very
yes,
clear.
there is a
para 7, para 7 re.
7.
I had not seen Rukmini. Deceased. After Rukmini, the accused went to her house. I had not seen Rukmini. Came to our house. They have not come out of their house. They have not seen the incident.
Yes. So, likhi diyon tapare hala. Even, however, in the cross-examination, PW3 has stated that while the deceased was talking with Pana, P-A-N-A, comma, he had not talked with the appellant. The appellant went to her house without saying anything to the deceased. After the appellant went to her house, he has PW3 had or C had not. C means bracket like the PW3. She had not seen the appellant coming to their house. And after the appellant went to her house, Bonamari came out from their house, and when Bonamari went out from their house, C bracketed PW3 and her sister had not come out of their house. And after hearing the shout, they came out from their house and found the deceased was lying dead in front of his house. In view of this evidence which has been elicited in the cross-examination, it is difficult to believe that PW3 had in fact seen the assault by the appellant on the deceased by a knife.
As stated in her.
As stated in her examination in chief. Now coming to the and that is the reason why the Lennon trial court has also not placed any reliance on her version. Coming to the evidence of PW6, the next occurrence witness, we find that she has stated that PW3 called the deceased and told him that Pano was quarreling with her and she was removing her from the house. And PW3 told to the deceased that she would call a meeting and requested the deceased to go to the meeting. And then the deceased accompanied PW3. PW6 further stated that she also accompanied with them, and her husband told to Pana Bariya bracketed PW5 as to why she was quarreling with her younger sister, and at that time the appellant was present in the house of Sojana Kiyo. Examination PW3, and she told to the deceased that he bracketed deceased was uh, indicating to her মানে bracketed deceased like them. Appellant. And then the appellant came from her house, caught hold of the deceased. PW6 further stated that while she was separating the appellant, the appellant caused hurt to her on her right arm. She further stated that she didn't know anything further about the case. In the cross-examination, PW6 has stated that the appellant came and without saying anything caught hold of the deceased. And when the deceased fell down, the appellant was standing, and that she had not seen any injury on the part of the appellant.
Hence he left the place.
She left the place. Therefore, the PW6 has seen a part of the occurrence. However, the star witness on behalf of the prosecution appears to be PW8, who has stated that on the date of occurrence, while he along with Arakita Bhoi were sitting on the veranda of S.K.SAHOO in the evening hours at about 8 p.m. At that time, PW3 and PW5, the two sisters were quarreling with each other. And at that time, the appellant was also present. Stop. PW3 called the deceased, who came there and told PW5, told PW3 and PW5 as to why they were quarreling at the instance of others. The appellant brought out a thought that the deceased was hinting at him, and she went to her house and brought a knife and stabbed to the deceased at 2 to 3 places. This witness further stated that the knife was seized by police in her presence as per seizure list exhibit 4 when the appellant brought the knife from the ura of her house. And she also identified the knife as MO1. Though the learned counsel for the appellant submitted or argued that the place of occurrence was not visible from the place where the where PW8 and Arakita Bhoi were sitting, but nothing has been brought out in the cross-examination to accept such submission. It was nonetheless duty of the defense counsel to bring on record either by way of cross-examination of PW8 or other witnesses examined on behalf of the prosecution or by examining defense, adducing defense evidence, the distance between the house of S.K.SAHOO and the spot, and also the position of the spot and whether the spot would be visible if someone sits on the veranda of S.K.SAHOO or not. Since no such endeavor has been made by the learned defense counsel, and there is nothing on record to come to the conclusion that the spot would not be visible from the house of, from the veranda of the house of S.K.SAHOO, we are unable to accept the contention raised by the learned counsel for the appellant. The learned defense counsel has asked how the occurrence has taken place, how the blows were given in the cross-examination, and the same has been stated by PW8, and the postmortem report findings corroborates the version of PW8, and there is nothing to disbelieve the evidence of PW8 as an eyewitness to the occurrence. From the evidence of PW8 coupled with the evidence of the doctor, bracketary PW4, and the postmortem report, bracketary exhibit 2, we found that the Lenin trial court is quite justified in arriving at a conclusion that it is on account of the assault made by the appellant to the deceased by means of knife, the death has taken place, and that the death is homicidal in nature. Now coming to the contention raised by the Lenin counsel for the appellant as to whether the act committed by the appellant would come within the purview of section 302 of the Indian Penal Code, or it would fall within any of the exceptions as enumerated under section 300 of the Indian Penal Code, and that it would be a case under section 304 part 1 of the Indian Penal Code. We find that the occurrence took place all on a sudden. There was no previous hostility between the appellant and the deceased. The occurrence took place when PW3 and PW5, the two sisters, were quarreling with each other, and one of the sister, that is PW3, went and called the deceased to pacify the matter. Neither the deceased nor the appellant were party to the quarrel. When the deceased arrived at the scene of occurrence and advised the two sisters not to quarrel, and further stated that why they were quarreling at the instance of others, the deceased who was, the appellant who was present there uh, came under a misconception that the deceased was hinting at her. And thereafter, the occurrence of assault has taken place. It appears from the evidence of PW8 that there was also quarrel between the appellant and the deceased at the spot, and there was tussle between the two when the deceased protested to the appellant. The appellant was also sent for medical examination, and PW10 examined her on 18/7/2003 and noticed the following injuries. Page number 73, 1 and 2. Therefore, it appears from the evidence on record that the occurrence has taken place in a sudden and unpremeditated manner, and the appellant has acted in a fit of anger. At this stage, we shall refer to the off-quoted decision of the Honorable Supreme Court in case of Surinder Kumar versus Union Territory, reported in AR 89 Supreme Court 1094, wherein it was held that to invoke exception 4 to section 300 of the Indian Penal Code, 4 requirements must be satisfied, namely, 1, it was a sudden fight; Roman 2, there was no premeditation; Roman 3, the act was done in a heat of passion; Roman 4, the assailant had not taken any undue advantage or acted in a cruel manner. It was further held that the cause of quarrel is not relevant, nor it is relevant who offered provocation or started the assault. The number of wounds caused during the occurrence is not a decisive factor, but what is important is that the occurrence must have been sudden and unpremeditated, and the offender must have acted in a fit of anger. The offender must not have taken undue advantage or acted in a cruel manner. In the said case, the deceased had sustained number of injuries as described in paragraph number 6 of the judgment. And the weapon of assault was also a knife, which the appellant picked up from his kitchen and assaulted the deceased during the quarrel. The wound, which proved to be fatal, was inflicted on the left flank at the level of on the fifth rib, about 2 inches below the nipple. The Honorable Court held that merely because 3 injuries were caused to the deceased, it could be said that he had acted in a cruel and unusual manner. Therefore, found the accused Surinder Kumar guilty under section 304 part 1 of the Indian Penal Code. Please take it.
Subscribing the views of my learned brother, in order to embolden the reason assigned in bringing the case under one of the exception of section 300 IPC as under. Admittedly, the appellant was not having even an inkling, INKLIN, that the deceased would appear at the scene of occurrence, as she had no axe to grind against him in the given facts and circumstances. What triggered the appellant is the statement of the deceased when he dissuaded the two sisters quarreling with each other at the instance of another. Stop. The appellant, who was nearby the place of occurrence, took it to herself, presuming the deceased indicating her as the third person at whose instigation the sisters were quarreling. Stop. Being enraged with the said statement of the deceased, alone the appellant got provoked and retaliated by causing harm to the deceased and retaliated to cause harm to the deceased and rush to assault the deceased by means of knife brought from her house. From the manner of injuries, though the assault seems to have been inflicted in utter cruelty, in absence of a on in absence of a premeditation, being in a sudden provocation, can only be inferred that the appellant intended to kill, and as such, all the ingredients necessary to bring home the charge under section 302 cannot be said to have been established. The gamut of evidence, the circumstances the manner of assault, and the infliction of injury, therefore, could only be taken as part of the provocation and sudden and has been inflicted in a fit of anger and would constitute the act culpable homicide not amounting to murder within the ambit of section 304 part 1 IPC.
Conclude karte hain. In the result, the judgment and the conviction of the appellant under section 304 or 302 of the Indian Penal Code is set aside. He is convicted under section 304 part 1 of the Indian Penal Code and sentenced to imprisonment for RI 10 years. RI for 10 years. Since there is no material before us that the petitioner, the appellant has already undergone such sentence, and by the time he was granted bail, he has remained in custody for 8 years and some months. After verification, if it is found that she has not undergone the sentence awarded by us today, the the appellant has to surrender to serve out the remaining part of the sentence with the subject to 428 of the CRPC. Accordingly, the jail criminal appeal is partly allowed and put a note of appreciation on Mr. Misra and Mr. Sonak Misra also. Okay.
Deeply obliged, man.
No, we are coming here at 10:30. We are there to take up the matters, but sometimes it is found that the councils are absent. So if you are ready today, just indicate the number to the Land and State Council so that he will also get prepared. And even though serially some matters will not be there, we can take up your matter. So please take the number and get prepared.
Yeah, I'm ready.
हाँ जो अपन
Yes,
दे
yes.
तो number दे दो.
Lordship, may I only make a mention? Item 29.
हाँ
That
Yes, Milord, I am there for the appellant.
391 CRPC.
हाँ.
Sorry,
Lordship,
Milord, I am.
I have informed the IIC. We will file a application under 391 for exhibit.
He's alive.
I have informed him. He will take that instruction, Your Lordship.
That is the most important thing.
My
And
Lordship.
sure.
My Lordship.
So this is that is as such. But if it is not taken off on by Friday, then we have to make it part hard and keep it to the next week.
Lordship.
So that you can prepare that application, if any, 391 CRPC for exhibiting that document. And the procedure is there. You have to serve a copy. You will be given an opportunity.
My lord, my
file
lord.
objection, if any. All these things are there. Then after our order is passed, it will be sent ultimately to the court, one of the courts in the either session judge or any of the ADJ. He has to record that evidence, exhibit that document, and then send the evidence copy to this case, and then the further hearing will continue. So that is the procedure. So first of all, you take instruction as to whether the person concerned or any other person who is accustomed or aware about his handwriting and signature of that IO is there or not. In case he is dead, we do not know. So that also.
Milord, may I pray? May I
Yes.
pray, Milord? Milord's kind interested that Lordship may kindly, but the IIC may be directed to inquire about the whereabouts of the appellant, because I have also, this is a jail criminal appeal.
I think we have ascertained that he is alive now.
Alive, but the address is not, is from outside state.
Unknown, Your Lordship.
Whereabouts
part-
ଜାଣିନାହାନ୍ତି କିନ୍ତୁ alive ଅଛନ୍ତି ନା ତ ସେ ପୁରା already query ହେଇକିନି
ଆଜ୍ଞା,
report furnish କରିଛନ୍ତି
see, ବର୍ତ୍ତମାନ କାଲି ଯେତେବେଳେ honorable court is not going to pass order, I have to not inform because his right to be, because I am not able to access. So I take the help of my friends, government counsel, so that at least the IAC may be directed to.
So they have I think
This-
there is a report, na? He is alive.
No, my lord, that is not there. I think the
No. It was placed, I think. But
no,
it
my
is
lord, that is whereabouts that local address is not found.
କୋଉଠି କାମ କରିବାକୁ ଯାଇଥିବ ଇଏ କରୁଥିବ, that's a different matter, but I think the report has come that he is alive. Mr. Mishra?
Yes, Your
Well,
Lordship.
but that report, your lordship, may see
अरे
he
ଆମେ
has
ପରା
lost.
ଦେଖିଥିଲୁ ସେଦିନ କଣ
Alive जो थिला bail टा तरह तो grant the honorable chief justice has recorded his order. But so far the report has come that he ascertained from the
ଲେଖା ହେଇଛି
local.
ପଢି ଦଉନାହାନ୍ତି।
Gotcha. With reference to the above cited JCRA number and subject, I have the honor to submit that inquiry was made at Vedavyas Ruguditola Mandir Road and nearby vicinity by examining the local villages, namely so and so.
Yes.
It is ascertained that the appellant Mohan Sahu had committed murder of his wife and sentenced to jail custody. Since then, he has not returned back to the said village. Nobody in the locality could be able to tell his present whereabouts. This is the only instruction.
Whereabouts?
Yes.
So once, my lord, this aspect will be 391, his right to, my lord. So I humbly pray at least he should be informed because right will be infringed. So I may pray the help of.
One way, because his presence would be necessary.
Yes. So I have to, my lord, to inform him. And to, cross-examination part is there.
Ignore his presence.
Yes.
And the
again,
instruction
Yes,
which
once the
is
evidence is recorded means his presence is
which
Yes,
is
my lord.
likely to impart to the London Defense Council. Let us say now a state defense council will be engaged. Let us say he is not in a position because it's a jail criminal appeal. In the trial court, when we send back the matter, one of the counsel is to be engaged, na?
My lord, my lord.
Questions to the IO in the cross examination, and he should be also a competent counsel to conduct the sessions trial cases, because it's a 302, that is the in the High Court also it has been mentioned that 10 years experience is necessary.
My
So
lord.
one person, one defense counsel is to be engaged. He has to take necessary instruction, and on the date of that recording also, it
He
is the
should
right
present.
of the accused to remain present.
My
You
lord.
cannot take everything in the behind the back of the swan show. Since it's a jail criminal appeal, also that instruction is necessary. So while you are filing this that 391 CRPC application, take all these
My lords,
instruction also. You
Gotcha.
follow that
Grateful.
what the consequence is likely to follow. Okay.
Gotcha.
Grateful, my lord. Obliged.
procedural laws regulating proceedings in court are to be construed as to render justice wherever reasonably possible and to avoid injustice from a mistake of court. Procedural laws like the Code of Civil Procedure are intended to control and regulate the procedure of judicial proceeding to achieve the objects of justice and expeditious disposal of cases. When a statute prescribes to do a particular thing in a particular manner, the same shall not be done in any other manner than prescribed under the law. The purpose behind beginning the argument from the side of the respondent is to satisfy this court as to how the election petitioner has failed in its attempt in substantiating through oral as well as documentary evidence that the nomination of the respondent has been improperly and illegally accepted, and that the respondent has not submitted his nomination paper in the prescribed Form 2B and that he has filed false affidavit in Form 26 along with the nomination paper, for which no relief can be granted to the election petitioner. After the argument from the side of the respondent is closed, since the burden of proof lies on the election petitioner to substantiate his pleading, he has to reply and satisfy this court through oral as well as documentary evidence adduced during the proceeding that the nomination of the respondent has been improperly and illegally accepted and that the respondent has not submitted his nomination paper in the prescribed Form 2B and has filed false affidavit in Form 26 along with the nomination paper and thereby violated the election rules and acts for which the election of the respondent is to be declared void. In view of the foregoing discussions, I am of the humble view that it is the learned counsel for the respondent who is to address the court first generally on the whole case, and then the election petitioner will give his reply generally on the whole case. Needless to say that after the reply is given by the election petitioner, if the learned counsel for the respondent feels it necessary to address this court further, he can do so with the permission of the court. Accordingly, the date is fixed to 13th November 2023 for argument, and the learned counsel for the respondent shall begin the argument. The matter will be taken off at 2 p.m.
At 10th November, we will file an application to give some time.
See that on that day it will be listed. We'll see that. Yes.
Item number 2.
Yes, time is extended.
Item number 3.
May I please, my lord?
Time is extended.
My lord, may I seek your lordship's pardon to make a mention, my lord?
Which matter?
My lord, a BL.
This is not, this is a disposed of case. He has written a letter for extension of time. You have nothing to say in this matter. Yes, next.
Item 4.
Time is extended.
Item number 5.
Yes.
Convicted under section 20B2C, my lord. Sentenced for 10 years and fine of rupees 1 lakh. Custody since 28, 2014. On the last occasion, my lord was pleased to call for the.
You are appearing for whom?
I am appearing for appellant number 4, Biswajit Roy. I am appearing for appellant number 6.
Appellant number? 6. There are bail application of 3, 4, and 6. So who is appearing for 3? No one.
Then senior Mr. Chand was appearing.
All right, but he is
Lordship,
not
he is
today.
not here.
Appearance. So you are appearing for 4.
4, my lord. 2238 of 2023, my lord.
What is the name of appellant number 4?
Biswajit Rai.
And what about appellant number 6? Because? So what is the conviction and what is the sentence here?
10 years is the conviction, and sentence is for conviction is under section 20B2C. Sentence is for 10 years and fine of rupees 1 lakh. Fine of rupees 1 lakh. 2 lakh.
What is the relevant page of the judgment?
Lordship, my lord.
10 years and 1 lakh fine.
Okay. Lordship.
In default to undergo RI for 2 years.
2 years.
Okay. So what sentence you have already undergone?
Since 28 2014 we are in custody, my lord. More than 9 years. That
Have you obtained the
Yes,
that
custody
custody certificate?
is 6 years 9 months.
Huh?
So for this Biswajit
Roy.
Roy is concerned, my lord.
Yes.
6 years 9 months.
28/8/14 ମୁଁ custody की गली.
This is the custody certificate I have received.
28/14 गली.
केबेकार सेटा केबेकार रिपोर्ट.
11/11/2023.
11/11/2023.
11/10/2023.
11/10/2023. हाँ.
11
ठीक अछि. 11/10/2023 रे केते आछि?
So 2553 days. It is equivalent to 6 years 9 months.
हाँ, that 6 years 9 months. Yes. Then are you calculating that?
Lordship, madam. I'm in custody since 28.
You must have been the same. That period has been detailedly mentioned therein.
Yes,
so
My
that
lord,
period starts from which date?
I think my land that has not been properly calculated.
No.
Lordship, madam.
18 June 2024. Right.
Yes.
Yes, madam. 18 June 2014. June 2019. So small letter.
From 18/8/2014, that is the date of occurrence. On the next day, they were forwarded. 19th August.
25. Yes.
कौन है ना 18
August.
18th August.
June लिखा है.
हाँ 18 June 2014.
18
ନାଇଁ 18/8 ପୁରା ଘଟଣା ହେଲା. So either 18/8 ରେ ଯାଇଥିବେ ନହେଲେ 19/8 ରେ ଯାଇଥିବେ.
19/8
ହଁ ଏଇଆ ହେଇଥିବ.
देखा जाउनी टे.
ହଁ ଠିକ ଅଛି. 19/8 ରୁ ପୁଣି କଣ ହେଲା? ତାପରେ ଆଉ କଣ ହେଲା? 19/8 ରେ ତ ହେଲେ ବେଶୀ ପିରିୟଡ ହଉଛି. हाँ ସେଇଆ ହେଇଥିବ.
Interim bail 8 months ପାଇଁ ଯାଇଥିଲା.
ହଁ
For 8 months, madam.
You are telling that 9 months କେତେ 9 months କେମିତି ହବ? 9 years.
Total that
Including
You have to tell that how much.
including that I have stated.
2553 days.
Including that I have stated.
So that means it is 6 years କେତେ କହୁଛନ୍ତି?
9 months.
9 months. And so far as Vikas is concerned,
That has not come. मैंने अलगा मानकर आस्ते जी.
आर केते जो
विश्वजीत राय एटा.
appellant number 4.
Yes, sir.
Appellant number 4 गला. Appellant number 3 you are appearing na Mr. Chan?
बाबू तो small car madam.
Appellant number 3 ହେଲା.
बाबू तो.
Yes,
हाँ बाबू तो small car.
बाबू तो मत 3117 days.
केते ହେଲା हिसाब को?
8 years 5 months.
8 years 5 months. এই কোର୍ଟରୁ ବେଲ୍ ରେ ଯାଇଥିଲେ ଆପଣ?
ନାଇଁ yes, my lord, granted interim bail
କେବେ?
by my lord in just give me a second.
16/4/2023 to 17/4/2023.
ମାନେ କାହାକୁ ଆପେଲାଣ୍ଟ ନମ୍ବର 3 କୁ?
My lord.
Ek dun teen.
Babu
Appellant
to-
number 1 and 2 in the meantime, my lord has granted bail previous date, my lord. And it's because the name of the appellant number 3 was not properly typed out. That's why my lord has permitted me to put not pay so far that particular part is concerned and granted bail to appellant number 1 and 2, who is similar to 1 and 2.
No, it's all right. Now, ନାଇଁ ମୁଁ କହିବା କଥା 3 କେବେ ଆଗରୁ ବେଲ୍ ରେ ଯାଇଥିଲେ?
1 2 3 ଏକା ସାଙ୍ଗେ ଯାଇଥିଲେ।
ଓ ଯାଇଥିଲେ। And what about appellant number 4? Mr. Tripathi? 4 କେବେ ବେଲ୍ ରେ ଯାଇଥିଲେ?
Yes,
interim
my
bail?
lord. In para 2 of my I have stated.
No, it's all right. Just खाली जाने हो।
About 8 months I was in bail. Once for
What
once,
about because you have not ascertained?
No, no, that has not come. I will take it. Bring it.
So এই ଯୋଉ order pass ହେଇଥିଲା 1 2 ପାଇଁ କଣ pass ହେଇଥିଲା?
Appellant bail କରିଥିଲେ my lord has granted bail just previous date.
Lordship can have us. Copy ଟା ଅଛି Lordship can.
ଓ ସେ मोहम्मद मुस्लिम केस समझे ଅଛି।
Lordship can.
अच्छा लिखନ୍ତୁ। And this Vikas was also, have you, that's just ascertain it will be taken off. ଶୁଣନ୍ତୁ ଆପଣ ତାଙ୍କର ଡେରି କରିଦେଲା ମାନେ କ୍ଲାଏଣ୍ଟ ଆସିବ ବ୍ରିଫ୍ ଟା ନେଇ ପଳେଇବ ତାଙ୍କର। ଏ ଦି ଜଣଙ୍କର ବେଲ୍ ହେଇଗଲା, ସେ ବେଲ୍ ଫାଇଲ୍ କରିଛନ୍ତି, ପରିସ୍ଥିତିକୁ ବୁଝନ୍ତୁ, ବୁଝିଲେ? ତ ନେକ୍ସଟ ୱିକ୍ ରେ ନିଆଯିବ ଯେମିତି ହେଲେ ଆଣନ୍ତୁ। ଆପେଲାଣ୍ଟ ନମ୍ବର 4 ର ଲେଖନ୍ତୁ IN number 2238 of 2023. This is an application for bail of appellant number 4, Biswajit Roy. Considering the submission made by the learned counsel for the appellant that out of 10 years of substantive sentence imposed by the learned trial court, the appellant number 4 petitioner has already undergone 6 years 9 months of sentence, and he was released on interim bail for some period by this court, and after availing the same, he surrendered at right time, and even though the paper book has been prepared, there is no chance of early hearing of the appeal in the near future. And after hearing the learned counsel for the state, who has not disputed about the sentence period of the appellant number 4, and in view of the ratio laid down by the Honorable Supreme Court in case of so and so, I am inclined to release the appellant number 4, Biswajit Roy, on bail. Then, so far as appellant number 3 is concerned, तादेरे खाली से कस्टडी टा सेम रहिबो, आधेरे पीरियड टा होची 8 years 5 months, हला? आउ बाकी सब समान रहिबो। So he was also that bail is allowed. So नहीं, appellant number, sorry यार, appellant number 6 को आप 6 पाएं। So 4 या 6 bail allowed. अपन कहाँ पाएंगे? अच्छा अच्छा सॉरी 4 and 3 एटा 3 टा। So appellant number 6 रो अपन आनी ना दिपा। अच्छा appellant number 6 रो bail application number केते? IN number केते? What is your IA? काहीं? मुड़ू IN नहीं bail को। What is it now? So 3 and 4 allow कर देला तो? हाँ, अच्छा हाँ, appellant number 3 टा होची
2564
हाँ, appellant number 3 टा होची 2564 of 2023, ता ना होची कौन भक्तोष मलकार, आउ appellant number 4 ना होची विश्वजीत रॉय। So हाँ, appellant number 6 रो आया होची 256 6 ର bail application number होची IA number 2550 cause list टा देखुनादी हला बुझिले तो Mr. Chand, your bail application number is 2564. You are for appellant number 3. Right? Mr. Tripathi, your bail application number is 2238, right? So number 4 allowed, this is number 3 allowed. तापरे आईटा लिखंदु IA number 2550 of 2023. This is an application for bail of appellant number 6. ता नाटा होची Vikas Biswas, hala? Learn and counsel for the state seeks some time to obtain the custody certificate of the appellant number 6. Please this matter on Ajihela 8 Tarikh, 15 Tarikh, 15th of November 2023. Yes.
Item number 6.
6 made, please, so Lordship. So in the first item, my lord, I have filed an IA praying for a modification, my lord. That is IA number 2067, my lord. Lordship, may kindly see that IA, my lord.
You want for modification of two orders.
My lord.
One is dated 5/9/2022. The other is 14/12/2022.
My lord, my lord. My lord, at the time of granting bail, my lord, there was a condition imposed by this honorable court that she should deposit.
That bail order was on 5/9/2022.
My lord, my lord.
5/9/2022 order ta bhar kala. 5/9/2022. ଏଟା କଣ ଦେ what condition you want to modify?
The condition was, my lord, she should deposit the entire fine amount. Fine amount was for 27 lakhs, my lord. Lordship has stated the realization of fine, but there is a condition that she should deposit 6 lakhs at the time of release on bail, my lord, and after that 1,75,000 for per month, my lord.
I said you are to deposit cash surety of rupees 6 lakhs
my lord.
At the time of release on bail,
My lord.
And then you are to deposit balance amount of rupees 21 lakhs.
My lord.
That too in 12 equal monthly installment.
My lord.
And how much amount you have deposited?
My lord, till date, my lord, I have deposited more than 50%, that is to 15 lakhs as per today, my lord.
So that averment you have taken in that
my lord.
IA number 2067.
My lord, IA number 2067.
Which paragraph you have stated?
My lord. My lord, paragraph number 13, my lord, page number 8 of that application. As I have filed this application on August, my lord, till that
it's all right. You have rightly said that you have mentioned it.
My lord,
that
my
you
lord.
have deposited 50% of the amount.
My
But where is the documentary
the
proof?
document I have annexed, my lord.
Where is that?
Annexure 1 series, my lord. Annexure 1 series, my lord. Basing on that, my lord, Lordship has asked for direction from the learned, my lord, Chief Judicial Magistrate, Mayurbhanj.
Report kahin?
Lord, the report has come, I think, on the record itself.
Also, bail condition deposit so and so.
সেটা
Hmm.
মেডিকেল রিপোর্টটা।
Huh?
This is the medical report.
Medical report nemo se tonka kete
সেটা
deposit
লর্ডশিপ has directed the trial court
ha
to give.
kain se report कौन दे दोजो
It is
in compliance to the direction of the honorable court given in so and so to submit a perusal of the case diary connected with the documents. It is found that the appellant Satrupa Mahanti has already deposited a sum of rupees 14,50,000 till date, pursuant to the order of this court. Who date kete din diaichi. So now what do you want?
Lord, I want, my lord, another thing is, my lord, is suffering from breast cancer, my lord. For that also, my lord has directed the state to obtain instruction. There is a report also. Lord, she needs an urgent medical attention, my lord. She needs a surgery. For that, my lord, I want, my lord, lordship may relieve her from at least, my lord, paying any more, my lord, installments, my lord. She was already operated once, my lord, in 2019. I have produced that record also. She has no job of her own, and her father is a retired lord servant. His only monthly income is 26,000.
Yes, Mr. Tripathi. She has deposited more than 50% because 27 ଲକ୍ଷରୁ 13,50,000 ହଉଛି ସେ ଆଉ 1,00,000 ଟଙ୍କା extra ମଧ୍ୟ ଦେଇ ସାରିଲେଣି. Now his condition is this breast cancer, so operation has also been done. Right, take down IA number 2067 of 2023. This is an application for modification of the order dated 5/9/2022 and 14/12/2022. While admitting the petitioner to bail as per order dated 5/9/2022, the following condition was imposed. The operative part likhi debe. The order was modified on 14/12/2022, and the operative part of the order is as follows. Quote kar debe. Say modification. As per the order of this court dated 18/10/2023, the report has been furnished by the London Chief Judicial Magistrate Moyurbanj Baripada to the effect that the appellant has already deposited 14,50,000 till 18/10/2023. Stop. A ground has been taken in the interim application that food election se ground jo deha bisare.
Milord,
Acha, that the petition that the appellant is suffering from
paragraph
paragraph
12 and
number
13.
12 and 13 जो लिख दो है ना पूरा टिपियन तक वो सम अप कर दे. Medical reports have also been furnished. The London Council for the State has obtained instruction to the Deputy Superintendent of Police, EOW CIDCB Bhubaneswar, written instruction कर दे, in which the report of the Chief Medical Services sum ultimate Medicare has been annexed, which indicates that the appellant came to the OPD with complaints of so-and-so, and it was detected like this, advised medication, so-and-so. So, in view of the health condition of the petitioner, appellant and financial condition, the order dated so and so is modified, and it is ordered that in case of the balance cash surety, the petitioners are furnished property surety to the said for the said amount, for the balance amount. Okay, the order is modified to that extent.
I am in the sub item.
Just in place of cash surety, property surety, property security for the balance amount to be furnished. Yes, Mr. Bahali, conclude.
I am the appellant is the more than 75 years old, and he remained in custody for more than 8 years. And on 1/8/2023, your lordship granted interim bail for a period of 3 months.
Which order?
1/8/2023.
Yes.
Looking at the medical condition, and he cannot move, and he has remained more than 8 years, and he is a old person and is suffering from different ailments. Complete treatment is also required, and he is urinating in the bed also. So he is considering all these aspects, your lordship granted 3 months.
3 months bail, right?
Now it has expired, and I have filed IA before the expiry and with medical document. Last occasion, your lordship directed to take instruction in the matter to the government council.
What is the present IA number?
Present IA 2459.
2459. What ground you have taken in this IA?
IA, this medical document I have given.
Okay.
And last occasion you will directed them, but in the meantime, the appellant already surrendered on 3rd.
Surrender health ए application au काम करिवनी. आपण को fresh application दबाव पड़ियो. बुझिले? लिखंदो IA number 2459 of 2023. This is an application for extension of the interim bail order dated 1/8/2023. The London Council for the petitioner, Mr. Bahali, submitted that the interim application has become infructuous as the petitioner has already surrendered in the court below, and he seeks liberty to file a fresh interim application for bail. In view of such submission, IA stands disposed of, giving with liberty.
Medical report may be called for from the.
केमती आपण गोटे देले सिना हबो
Tomorrow I file.
हां फाइल there is no problem in that.
More file you lordship called for clear.
File first file make a mention, immediately matter will be listed and you will seek inscription, है Yes.
Item number 7.
Item number 7, my lord, file an interim application for interim bail.
That is IA number 2362 of 23.
My lord.
Yes.
And your lordship previously directed the state council.
On what ground you are seeking for interim bail?
My lord, the mother-in-law of the petitioner,
yes,
who is 85 years old, and she has been discharged by the doctor unsatisfactorily because nobody was there to attend her on the bed, and she requires. Your lordship will find page 7, the doctor's discharge certificate. Not satisfactory, poor prognosis is experiment. The age is 85 years. So she needs some. No one is there because the husband of the appellant is not available in the house. And previously, your lordship granted
So,
twice.
Mr. Tripathi,
My lord,
what instruction you have received?
I have given. Genuine.
He is a local man.
Yes,
Right.
she's a lady.
IA number 2362 of 2023. This is an application for interim bail on the ground of ailment of the mother-in-law is stated to be aged about 84 years. Some medical document in annex to the application. London Council for the State was asked to obtain instruction on the interim application today. He has produced the report from Inspector of Excise Atgod Range, Kamak, and it indicates that the mother-in-law of the petitioner is suffering from chest pain, head reeling with slurred speech, and the medical document attached to the IOA is genuine. The documents may document further. And there is no male member to look after her mother-in-law. Considering the submission made by the London Council for the respective parties, the government's taken in the interim application and the report furnished by the London Council for the state, I am inclined to release the petitioner on interim bail for 1 month. IA is disposed of, shall surrender before the trial court and produce the surrender certificate. Yes.
Can it be some more time? 3 months ago. ଆଗରୁ ବେଲ ଇଣ୍ଟରଭ୍ୟୁ ଯାଇଥିଲା ଠିକ ଟାଇମରେ ସରେଣ୍ଡର କରିଛି there is no
Correct କରିଦିଅନ୍ତୁ till end of December କରିଦିଅନ୍ତୁ December 2023. Next.
Item number 8.
Actually, for 3 years, my lord, for offense under section 420, 120B, 406, and 456 of the prior cheat.
Is this coming for the first time?
My lord. And,
Just a minute. OPID means.
I have some copy to Mr. Patra on 1/11/2023.
Why is not coming to the?
And he has also given the receipt.
He has not given copy, my lord.
No, it is that OPID matter, Mr.
Yes, he has not given copy to the OPID. He has given.
No, Mr. Patra's signature is there in the to have received the one when he has received.
1/11/2023.
Why didn't you intimate that the matter is being listed today?
I will.
First 30th I had mentioned. Thereafter I had telephoned him. And sought a copy.
Defect to the service copy or defect on? How can defect?
How would a certificate be?
तो अभी तक कौन? Not cost title online, but not on address. IN number so and so. Affidavit not made. IN number 2530. At a bail. Bail application affidavit करना थी. हाँ? Bail application देखते हैं दी. ये से नोटरी की है. वो नोटारी सीलटा मारला ता दस्तखत नाही किछि नाही ता ना लिखिनी किए ताको आइडेंटिफाई करले ता देखेले ए कॉपीटा दियोन सेठी तो कहली पैसा परे देई बेली आ खाली सीलटा केन मारदला आपण आइडेंटिफाई कलो सीता सील ले किछि सिग्नेचर देनी हां डिपोनेंट तार ना लिखिनी तारो signature nahi kichi nahi se defect dekhichandi bartaman this will not be accepted. You are to file a fresh affidavit. All right, let it be there in the list to remove the defect. All right, supplementary list ang na likhi delo se jo di jonakor na Vivekanand Bhuiya au tankori ha the learned se memo ta diontu the learned counsel for the appellant has produced the receipt showing service of copy of the appeal memo on the Mr. J.P. Patro and special counsel appearing for the state of Orissa in OPID Act matter. Since the names of the counsel for the state in OPID Act matter had not been reflected in the cause list, none appears for them, none appears for the state of Orissa. Let the names of the learned counsel for the special counsel be reflected in the cause list. The learned counsel for the appellant submits that he will remove the defect number 9 as pointed out by the stamp reporter. Put up this matter on 9th of November 2023. आज को रिपेयर भी जाएंगे नहीं हाँ ठीक है
Madam, may I make a mention, my lord?
Good. Take the slot and maybe eat a fast for the man. Now you one thing, you make it on the day after tomorrow. For dinner occasion. That would be better. It will come day after tomorrow. Yes.
I beg pardon, madam, may I make a mention, my lord?
Yes.
Item 9, can it be taken up December?
No. Yes. Next. Yes. Hearing matters.
Weekly list item number 1.
My lords. Weekly list item number 1. May I be permitted to place on on behalf of Mr. Das?
Yeah. Okay, just
My lords.